It's fine.
Court calls the case State of Wisconsin versus Zachariah Rasch, case number 24 CF 306. Appearances, please.
Andrew Will appears on behalf of the state.
Good morning, Your Honor. Zach Zahawi, Merle Josty on behalf of Mr. Rasch. Also present is Samantha Denamer. Mr. Rasch is before the court.
Sorry, I apologize. I forgot the other people at the state's table. Assistant DA Sean Wooler also present, and Detective Justin Cotney.
All right. Before we talk with the defendant, and actually, let me maybe the counsel, is the defendant intending to testify?
Yes, Your Honor.
All right. The first thing that we need to address is the number of prior convictions that the court will allow. Are there prior convictions? It appears to me that there is 3, I believe.
Yes, the state's position is 3. There's more than 3 prior convictions, but the number that the state believes is relevant under the case law are 3.
James Howie.
One moment, Your Honor. I'm pulling it up, the dates. I see one from 2015, cited by the people, 2018 and 2019. We're requesting 2, Your Honor, being that 2015 is outdated. It's over 10 years old at this point.
All right. Well, the court does not believe that there is a significant lapse of time. It is, I recognize it's 11 years, but that is not a significant period of time, at least for the purpose of consideration. Gravity of the offenses, involvement with dishonesty, and the probative value outweighing any prejudice. It appears to me that the 3, as the state has set forth, would be appropriate. So, if in fact he were to give some testimony, he would be asked the question, have you ever been convicted of a crime? The answer would be 3. Legally, I believe there are more convictions, but they are older. So, sir, do you understand that?
Yes.
And you do need to understand that if you travel afield, if you decide to say something other than 3, that may lead to cross-examination regarding specific details of the crimes that are the subject of inquiry. Do you understand that?
Yes.
All right. Your attorney has indicated to me that, in fact, your intention is to give testimony here today. Is that correct?
Yes.
Now, you need to be very, very clear that you have a constitutional right to remain silent, that you do not have to testify. Do you understand that?
Yes.
You understand that, and you perhaps heard it during the course of jury selection, you are innocent until proven guilty. You do not need to prove your innocence. Do you understand that?
Yes.
You also, of course, have the right to make elocution. In other words, you have the right to make a statement if you wish. But you do need to understand that once you take the stand, you would be subject to cross-examination. Do you understand that?
Yes.
Yes. In other words, the state is going to be able to ask you questions Do you understand that?
Yes.
Now, have you had enough time to talk with your attorneys about this decision?
Yes.
Would you like some more time to talk with your attorneys about this decision?
No.
Has anyone forced you, threatened you, made you any promises at all in order to get you to make a decision to testify in this case?
No.
Is there any confusion, anything that you don't understand about those two rights, your right to remain silent and your right to give testimony?
No.
And you do understand that even as I instruct the court or the jury as to the law, I would tell the court that they are not to take anything from the fact that you did not testify. Do you understand that?
Yes.
Any questions at all?
No.
Counsel, Attorney Zahawi, have you had enough time to discuss this decision with your client?
I have, Your Honor.
I'm assuming that discussion happened perhaps today, certainly yesterday, and throughout the course of your representation. Is that correct?
That is correct.
So this is not a new concept that was just sprung on him. This was something that was discussed at length with him. Is that correct?
That is absolutely correct.
And do you believe that his decision is freely and voluntarily made?
I do.
Very well. Anything that you would like the court to address with the defendant?
No.
The court will accept and allow him to testify. I am satisfied that he understands his rights with respect to giving testimony, his right to remain silent and his right to make elocution. It appears to be that he's had enough time to talk with his attorneys about this decision, both today, yesterday, and as they planned the defense of this case. Decision appears to be freely, voluntarily, knowingly, and intelligently made. Doesn't appear that anybody has threatened him, forced him, or made him any promises to get him to decide one way or the other to give testimony or to remain silent. Appears to me that he's doing so of his own free will. The court will allow him to testify. All right. We have a couple of housekeeping things. First of all, I'm assuming that, and yesterday I believe one of the security officers checked, and there is tethering equipment that has been installed underneath the witness stand. My preference would be that he comes up when we decide to bring in the jury. Before we bring in the jury, that the tether is secured. The counsel approach and make sure that there isn't anything that they feel is concerning with respect to the tethering. Under normal circumstance, without the tether, I would have a guard seated next to the defendant in order to assure the protection of the jury. However, with the tethering, that would be eliminated unless, sir, some action by you provokes a concern in the mind of the officers that are assigned to protect the jury and court personnel. Do you understand that?
Yes.
So, assuming there isn't going to be any problems, we would do that. What I would expect is that we bring in the jury. The state has not formally rested in front of the jury. You recall the jury stepped out and we took care of a lot of housekeeping stuff, motions to dismiss and the like. So formally rest, call your first witness, and the defendant will be positioned up at the front.
So the defendant will be positioned
Right
prior,
now.
right now, okay.
Right.
Yeah, okay. That's acceptable. I would just like to take a look from the
Yeah.
the juror's seat closest.
That's fine. We're going to go off the record for just a few minutes. We'll have security bring him up here, and then we'll investigate, allow you to take a look to make sure that everything is, in your mind, sound.
Okay, one last thing on a request, Your Honor. In the courtroom is Mr. Rasch's mother, Mary Rasch. She's on the prosecutor's witness list. She was subpoenaed, and she hasn't been released from subpoena yet. And I brought this up with DA Will. She is requesting, I think at this point, we'd like perhaps an indication from the prosecution whether they intend to call her as a witness, but she'd like to watch some portion of the trial.
All right, very well.
The state will release her from her subpoena at this point.
All right, ma'am, I don't know who, there she is. Okay, ma'am, you are released from your subpoena. You are free to sit in the courtroom and watch the balance of the proceedings. Thank you. All right. Bring him up, please. All right, we are in recess at this time.
I already did.
All right, sir. I'm going to swear you in. Just going to have you raise your right hand.
All right,
You don't need to stay.
Don't have to get up.
all right.
Let me see it's on your which leg? Oh, it's on both, okay. Yeah, just kind of push it. When you do, come in, just kind of push it forward, put your legs forward a little, so it's there. Okay, and then you can relax. So it's just a word, and then come in.
As long as they don't even have to stop. Even really right
placed on the witness stand, tethered is there any concern? Attorney Will?
No, the state did go to the top of the ramp and view the ankle shackles, both from the doorway where the jury would enter and then also from the jury box area. I viewed it from standing. I could not see the ankle restraints. In fact, I could not see the ankle restraints until I approached the witness stand and looked down, and there would be no circumstance where a jury would do that. So I'm satisfied that the jury would not be able to see any restraints on the defendant.
Attorney Zahawi?
Thank you, Your Honor. I also did the same viewing as DA Will and have no concerns at this time. Also grateful and thankful for the civilian bailiff to position himself between the exit of the jury room and in between the client and the jury box, which also helps. But so we're satisfied.
All right, and do you want him to remain there, or would you rather have him return there once the jury is excused?
Once the jury is seated, the civilian bailiff is free to move about the courtroom and in accordance with their duties. We would perhaps we would request that prior to the dismissing of the juror after Mr. Rasch's testimony, that the bailiff position himself again.
All right. We will make sure that occurs. I've instructed your client that I'll swear him in. Don't stand and just raise his right hand. So
Understood. Thank you.
we should be. And the other thing that I just want to make sure that all of us, everyone in the audience, family and alike, please, we have kept a very good decorum throughout the course of this trial. I see no reason whatsoever for decorum to change. You obviously are, this is an emotional time. It's an emotional time for both sides. And if you let yourself be overcome by those emotions, security will remove you. You will not be allowed to disrupt these proceedings. All right. With that, are we ready for the jury?
We are, Your Honor.
All right. Bring in the jury. Attorney Will, you'll rest, and we'll move forward. All right? right, well, good morning, ladies and gentlemen. Does anybody want to take a shot at, from memory, the instructions that the court has given you? No? Anyway, you recall those instructions? Did anybody violate those instructions last evening? All right, and you probably figured out my mixer came and a monster carrot cake has been created. So that'll probably be all gone at the first break, knowing you folks. So anyway, all right. Terry Will.
The state does rest, and for those of you keeping track, all of the state's exhibits that were previously marked have been moved into evidence.
They have been. All right. Attorney Zahawi, your first witness, please.
Thank you, Your Honor. The defense calls Zachariah Rasch.
All right, sir, raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Put your hand down, adjust that microphone, speak directly into it. Counsel.
Good morning, sir.
Good morning.
You're Zachariah Rasch.
Yes.
Okay, just so we get a little bit of background about you, where were you born?
Watertown.
Here in Dodge County?
Yes.
Did you always live here in Dodge County?
Yes.
Did you go to high school here?
Yes.
Up until what grade?
11th.
And can you tell the jury how old you are now?
44.
Now, after you graduated from high school, did you go to work?
Yes.
What kind of work would you do?
Factory.
And can you give us a little bit of background on what would you do within the factory?
Assembly.
What kind of products would you assemble?
There's all different sorts.
Okay. Do you know Crystal Rasch?
Yes.
You knew her.
Yes.
When did you guys meet?
2008.
Okay, so I'm going to ask a question that obviously is the scope of this trial is, did you kill her?
No.
Okay, so I want to talk about going forward from when you met her in 2008. In 2008, how did you meet?
Through some friends.
Did you have any children together?
Yes.
How many?
4.
And what are their names?
Nolan, Nicholas, Bryson, and Johanna.
Did you marry Crystal Rasch?
Yes.
When was that?
2013.
Where did you live once you got married?
And my parents.
Is that the address at N3251 Wood Road?
Yes.
Okay. How long did you live with your parents at that address?
A couple years.
Did you ultimately move in to your own place?
Yes.
And what is that place?
730 Main Street.
Okay. And we heard some testimony about that 730 Main Street was where Crystal Rasch was living in 2024. Is that the same house?
Yes.
All right. We also heard through this case that your children, Nicholas, Joanna, Nolan, and Bryson were taken away. Is that correct?
Yes.
Do you remember when that was?
2019.
Can you tell us a little bit about, how did that make you and Crystal feel in 2019 to be losing your children?
Depressing.
Okay. Well, can you tell us a little bit more? How did you guys cope with that?
It was hard.
And you were living at the 730 Main Street address at the time?
Yes.
Were you working at that time?
No.
Why not?
I had health problems.
Did these health problems prevent you from working?
Yes.
What kind of health problems?
I had heart problems.
you know that your children were ultimately placed in foster care? Is that right?
Yes.
And there was a Heather Doherty who testified in this case. Is that the foster mother of your children?
Yes.
Do you understand that at some point your children were, let's see how to put it, were at risk or slated to be adopted? Is that right?
Yes.
And how did you and Crystal cope with that?
It was depressing.
Was it tough on you guys?
Yes.
Was it tough on Crystal?
Yes.
When was the last time you saw your children?
2019.
Do you think that your children would recognize you today?
No.
Do you think that Crystal had maybe was a little bit more proactive in seeing her children?
Yes.
Now, ultimately, in your mind, do you feel that the children that are in foster care, that were in foster care and now are adopted, were in a better place than when you and Crystal had them?
Yes.
Did you feel that you and Crystal had the ability to take care of 4 children?
Yes.
Did you feel that you had the ability to take care of the 4 children as well as the Dohertys?
Yeah.
Do you think your kids are in a better place or a worse place now?
Better.
Okay. We heard testimony from Detective Contney that he spoke with a Brenda Acosta who was at 730 Main Street. Do you know Brenda Acosta?
Yes.
Who is she?
Crystal's real mom.
You mean her biological mother?
Yes.
When did you meet her?
It was like 2022.
Okay. How did it end up that you met her?
She just showed up.
She showed up from, do you know where she was living before?
Texas.
Did she give you any information about that she was coming to see you or to visit?
No.
Okay, tell us about that. She just showed up with, was she dropped off? Was she in a car?
In a car.
Was it her car?
Yes.
Okay. And so she shows up, and tell us about, the conversation or what happened after that.
She just showed up and stayed.
She stayed since 2021, 2022?
Yeah.
Was that, did you have a conversation with Crystal? Like, hey, why is your mom here?
No.
Okay. You just allowed her to stay with you?
Yeah.
Did she work?
No.
How was she supporting herself?
She wasn't.
Who was supporting her?
We were.
We as in you and Crystal?
Yes.
Okay. At some point, we learned also that Crystal filed for divorce. Is that right?
Yes.
Do you remember when that was? What year, I should say?
I think it was 2023.
Okay. Tell me about how did that affect your relationship after she filed for divorce?
It didn't really affect it at all.
What do you mean by that?
We were just living in different places.
Did you move out or did she move out?
I moved out.
What did you move back into?
My parents.
Okay. You say the relationship remained the same. Tell me about that between you and Crystal.
Yes.
Would you still see each other?
Yes.
Did you, let's say, socialize, go on dates, things like that?
Yes.
Were you intimate with her?
Yes.
Did Crystal bring you around her family after she filed for divorce?
No.
So were you going to, you weren't going to family functions like Christmas parties and 4th of July, things like that with her?
No.
How often were you seeing her?
It was quite a bit.
Like every weekend or every couple weekends?
It was like every weekend, sometimes during the week.
Now, you know Crystal you saw her pretty often. Did you ever see her taking any medication?
No.
We saw during some of the testimony, the photographs of a medication organizer. Did you ever see that before?
No.
And there was also testimony about mental health therapy or perhaps some cognitive issues like mild mental retardation. Was that your understanding about her as well?
Yes.
Is that how she presented to you, like when you were talking with her and interacting with her?
Yes.
Okay. Did you know that well, let me back up a little bit. You know that there was a plan in place for you and Crystal to get your children back, right?
No.
Okay, well, for Crystal, there was a plan to get her children back?
Yes.
Okay. Did you know that she was supposed to go to mental health therapy?
No.
She ever discussed this with you?
No.
Did Crystal ever introduce you to some of her friends outside of her family?
No.
There was the testimony from a woman named Robin Reels, and she said something to the effect that she didn't think you had been seeing each other for years. But you're telling us, in fact, you had been seeing her even after she filed for divorce, right?
Yes.
Now, moving out of at this point in your life, you've lost your children. Your wife filed for divorce, and you're moving back in with your parents, right?
Yes.
Okay. Now, how were you feeling emotionally? Were you like a happy person, or were you depressed, or what was going on with you?
Depressed.
Did Crystal tell you, like moving forward, like after the divorce was finalized, like how was your relationship going to be? Did she say it was going to be different, like she didn't want anything to do with you, or that it was going to be more of the same?
She never said.
Okay. Did you wear your wedding ring?
Yes.
Why?
She wanted me to.
All right, I want to back up, we'll move forward to June of 2024. But before then, let me ask you this. Do you have any prior convictions?
3.
Okay. So going back to early June of 2024, earlier you described your relationship as kind of, you were seeing her on weekends and sometime during the week. Is that the same in June of 2024?
Yes.
All right. That weekend of June 8th, June 8th was a Saturday, 2024. Did you make plans to be with Crystal?
Yes.
Can you tell us about those plans?
We made plans to go up to the Dells.
Okay. Is that something, when you say go to the Dells, where would you stay?
At our camper.
Is that the camper on the Adams County lot?
Yes.
Tell us about that lot. Whose is it?
It's my grandma's.
Is it a lot where she shares a lot with her family to stay there?
My family.
Yeah, your family.
Yes.
So who else has trailers on that lot?
My mom, my Uncle Rick, my Aunt Merlin.
Okay. And you and Crystal, correct?
Yes.
Did you guys buy that camper while you were married?
Yes.
Okay. And then you hauled it up to the lot and it's stayed there ever since?
Yes.
All right. So when you go to pick up Crystal, you were staying at this time in June of 2024 at your parents' house, correct?
Yes.
How far is that from where Crystal was staying on 730 Main Street?
It's only a couple miles.
Is it just down the road?
Yes.
Okay. So tell us about how you made plans to go. Did you call her or,
It was through Facebook Messenger.
okay. Where did you make plans to pick her up?
Saturday
Okay, where were you gonna pick her up?
at the church,
Which church?
the one on the corner.
Is it the one on the corner in Kleiman?
Yes,
How far is that church from her house?
it's on the same block.
Why were you picking her up at the church instead of at her house?
I'm not sure.
Is it something she asked you to pick her up there?
Yes,
Would you normally pick her up there from
Yes.
the church? Now, there are two churches in Kleiman. Would it be always at the same church or sometimes at the other church?
sometimes at the other church.
All right.
Counsel, if you could, the date of this interaction.
Yes, great. And this was, do you remember the date? I mean,
No,
if I said Saturday, June 8th, does that make, does that sound correct?
yes,
Okay. So Saturday, June 8th, tell us about what you do. You pick her up at the church and what happens?
we head up north
Okay.
on the Adams property.
Sorry, I was interrupting you. How do you drive there? What route do you take?
16.
Okay. Where do you go once you take the 16? Directly to the property?
Yes,
And what did you guys do?
we dropped off the clothes.
Okay. At the camper?
Yes,
And then what happened?
we left and went to the Dells. Walked
Would-
around.
Do you remember where you parked at the Dells?
It's by a laundromat.
And what did you do?
We just walked around looking at stores.
Do you remember any particular stores you looked at?
No,
Did you buy anything? Any food?
food.
Okay. What did you buy?
We went to Denny's.
Okay. And what do you remember? Is there only one Denny's in Wisconsin Dells?
Yes,
All right. So you walked around and you went to Denny's. Anything else?
no,
Do you remember what? Let me back up. Do you remember what time you arrived at the Adams County trailer?
no, not offhand.
Was it in the? But do you remember if it was like in the morning or in the afternoon or evening?
It was in the afternoon.
You headed back to. What did you do after you had food at Denny's?
We walked to strip in the Dells some more.
Okay. Do you remember any particular shops or anything you did at that time?
No,
All right. What did you do after that?
we went back to the camper.
What happened when you were back at the camper?
We went to bed.
Okay, how did she seem, Crystal, at this time?
Happy.
No issues between you? Was it this kind of the routine relationship you had?
Yes,
And how were you feeling?
happy.
Were you intimate that evening?
No,
Okay, going to Sunday, June 9, you wake up. And what happens when you wake up?
get dressed.
Okay, what happens after that?
We went to the flea markets.
Which flea markets?
Polish flea market and the Adams Friendship flea market.
Do you remember what time you headed out there? Was it in the morning?
It was in the morning.
All right. At the flea markets, what did you do?
We just walked around.
Did you find anything you like?
No,
Did Crystal find anything she liked?
no,
Did you go to both flea markets?
yes.
All right. And then, what did you do after that?
We went out to Gray's Closeouts.
What kind of store is Ray's Closeout?
It's a liquidators.
What do they liquidate? Everything? Anything?
It's everything.
Like if you were to walk in there, what could you find?
Tools, blankets, signs.
Anything at all?
Yeah,
Okay. Did you find anything you like?
No.
Did Crystal?
Yeah.
What did she find?
Toys.
Did she purchase them?
Yes.
Did she purchase them with her own money or with your money?
Her money.
Was she using her money throughout this weekend?
Yes.
So after Ray's closeout, what did you do?
We went to Wisconsin Rapids.
Okay. What did you do there?
Went to Goodwill.
Did you find anything you liked there?
No.
Did she?
No.
All right. And after that,
I went to the pawn shop across the street.
okay. Do you remember the name of the pawn shop?
No.
Did you find anything you liked there?
No.
Was when you were in the pawn shop, did Crystal come with you to the pawn shop at first?
No.
Where was she?
She was in the vape store next door.
All right. How did you guys meet up again?
She came into the pawn shop.
And then what where did you guys go after that?
Back to the vape store.
To the what store?
Vape.
The vape store? All right. Did she purchase any vapes?
Yes.
Do you use a vape?
Yes.
How often?
I was using it daily.
And then what did you do?
We went to Taco John's.
Okay. And safe to say you had a meal there or something to drink?
We ate.
I'm sorry?
We had a meal.
And by this time, do you know what time of day it was?
The afternoon.
What happened after that?
We looked at a house.
Like a house for sale or just like looking at a house on the street?
House for sale.
Whose idea was that?
Crystals.
Do you remember what the house looked like?
Not offhand.
Do you remember where it was?
No.
Was it in the Wisconsin Rapids?
Yes, it was.
Was it, can you give us any description at all of the house, like a one-bedroom, two-bedroom, or anything at all? The color of the house?
I think it was a 4-bedroom.
So why was, no, Crystal at this time, she wasn't working, right?
No.
But she was living in a house that you and her owned at 730 Main Street.
Yes.
Okay. Did she give you any reason why she was looking at a house in the Wisconsin Rapids to buy?
She said to be closer to my daughter.
Your daughter, which daughter is that?
Hope.
Now, Hope is not her daughter, right?
No.
She's a child from your previous relationship.
Yes.
How old is Hope?
25.
Does she live in the Wisconsin Rapids?
Yes.
Does she have a good relationship with Crystal?
Yes.
Okay. So how long were you looking at the house?
It was a good 30 minutes.
Then what did you do?
We left.
Where did you go?
Back to the camper.
Okay. What happened? So that's Sunday evening. Do you remember about what time you got back to the camper?
No.
What happened when you got back to the camper?
We decided to leave again
To leave again.
to the Dells.
Okay. Well, this was I'm looking at the night of June 9th. That's a Sunday night. Like when you went back to the camper, did you go right to bed or did you guys do anything? Campfire or anything like that?
No.
Okay. Were you guys intimate that night?
No.
Okay, going to Monday, June 10th. Did you make any plans that day?
Yes.
What plans did you have?
We decided to look at another house.
Where was this house located?
Wisconsin Rapids.
When Crystal woke up that morning, did she complain about her throat or say anything about having strep throat?
No.
Did she tell you anything about, well, let me ask you this. Did you know that she had regular appointments to see her children?
Yes.
Okay. Did she say anything to you about, well, did you know when they were?
Every Monday.
Okay. Did she tell you anything about not going to see her children that day?
No.
Did you ask her, like, hey, it's Monday, why aren't you seeing the kids?
She didn't say anything late till later.
What'd she say?
She wasn't going.
Did she appear to be ill from strep throat, like complaining about a sore throat or coughing or fever or anything like that?
No.
All right, so you go and see this other house, correct?
Yes.
Can you describe this house for us? I think you mentioned it was in the Wisconsin Rapids as well.
Yes.
All right, can you describe this house?
It was another 4-bedroom.
Was there a realtor there or open house of sort?
There was a realtor there.
Do you remember what color the house was, or can you give us any more details about the house?
No.
Okay. Did this one have a yard?
Yeah.
How did the yard compare to the house, this one, to the one you saw the day before?
It had a lot more of a yard than the other one.
What did you do after seeing the house?
I went to Taco John's again.
All right. And then what did you do?
Went to the Dollar Tree.
Did you find anything there?
No.
Did Crystal?
Yes.
What did she get?
Bunch of stuff for the camper.
Like what kind of stuff for the camper?
Forks, spoons, paper towels.
All right. So you were at the Wisconsin Rapids, and what did you do after the Dollar Tree?
I think we went straight to the Dells.
Okay. What did you do there?
Walked the strip.
Okay. Anything else?
No.
Anything significant that you did there or was memorable?
Not offhand.
Okay. After, so on Monday, June 10th, you were at the Wisconsin Rapids and then went to the Dells. What time do you remember leaving the Dells?
It was around 10 o'clock.
At night?
Yeah.
Where'd you guys go?
Back to the camper.
All right. One thing to ask you, you own a Taurus 9mm, correct?
Yes.
That you bought that in the, I guess, the spring of 2024.
Yes.
Was Crystal aware of that firearm?
Yes.
When you woke up on, well, let me ask you this. That 9mm, had Crystal ever shot it?
Yes.
Well, how many times?
Probably about 3-4 times.
Okay. When you say 3 or 4 times, it's not like three or four times, just 3 or 4 bullets. It's 3 or 4 different occasions.
Yeah.
How would you describe her competency or with the firearm? Like, was she very familiar with it, somewhat familiar, getting used to it, or very experienced with it? How would you describe that? Or
She wasn't very experienced.
did it appear to you that she's trying to get the hang of it? Or
Yes.
where would you shoot this firearm?
Up north at the campers.
All right, on June 11th, that is a Tuesday morning, you wake up and you're at the campsite, right?
Yes.
What did you guys decide to do that day?
To go to a lawyer's office.
Okay. Were you supposed to be at work on Monday and Tuesday?
Yes.
What happened?
I called in.
Saying you weren't coming in, or
Said I was sick.
why'd you do that?
To spend more time with her.
On June 11th, what's going on there when you wake up?
She's eating, drinking soda.
All right. And then what did you guys do that day?
We went down to Milwaukee.
Why'd you go to Milwaukee?
She wanted to see a lawyer.
About what?
Kids.
Your 4 children that were in foster care at the time?
Yes.
Where did you go in when you were in Milwaukee?
To a lawyer's office.
Okay. Before you got to the lawyer's office, did you make any other stops?
Culver's and Goodwill.
Okay. We saw some video of that in this case. Are those accurate?
Yes.
You tried to see some lawyers, correct?
Yes.
Do you remember the names of the law firms?
No, I don't.
All right. So the first one, you said, was it 1 or 2 lawyers' offices?
2 lawyer offices.
All right. And so we heard from Detective Cotney that on the flock camera there was one nearby a lawyer's office. Do you remember can you describe for us what happens when you went to the first lawyer's office?
She was out of the vehicle and in the building before I was.
Okay. Where was she? The building is in the law office?
Yes.
Did you meet up with her inside?
Yes.
Okay. Tell us what happened when you went inside.
She's trying to see the lawyer without an appointment.
Were you able to see a lawyer?
No.
What did they tell you?
Needed an appointment.
All right. Did you make an appointment for sometime in the future?
No.
Did you leave?
Yes.
Did you leave together?
No. She was out the door before I was.
How long were you in that lawyer's office?
Probably about 5 minutes.
What was Crystal's mood at that point?
She was mad.
Was she saying anything?
No.
How could you tell she was mad?
She stormed out.
Did she complain about lawyers? Or
Yes.
Okay. What was she saying?
Objection calls for hearsay.
I'm sorry?
Objection calls for hearsay.
Effect on the listener, Your Honor, not offered for the truth.
Sustained.
You've known Crystal for, was it 2013, right?
Yes.
Can you tell when she's upset?
Yes.
Can you tell when she's happy?
Yes.
At this point, you've known her for 11 years. Okay. What about her demeanor and what she was doing made you believe she was mad?
She stormed out of the lawyer's office. She's back at the vehicle before I was.
Okay. Then what did you do after that?
We left and went to another lawyer's office.
Whose idea was that?
Hers.
Was the other lawyer far from you?
No.
About how long did it take to get there?
About 3 minutes.
All right. Tell us what happened when you went to the other lawyer's office.
She didn't even get out. Neither one of us got out.
What did you do?
We left.
Well, you say you pulled into, did you pull into the parking lot?
Yes.
All right, so tell us what's going on when you pull into the lawyer's office.
She was mad. Said she wasn't going in. She was done.
Done what, about what?
That's all she said.
All right. How did you respond?
I just said okay and left.
All right. How long were you in the parking lot?
Probably about 5 minutes.
When you said that you were going to leave, did you guys make a decision where you were going?
No.
What was the plan at this point to do?
Take her back to the house
Her house where?
and climb in.
Okay, so at this point, you tried to see 2 lawyers, you were unable to or chose not to, and it's time to go back to climbing.
Yes.
All right, at this point, was the plan then to drop her off at her house and then you go to your home?
Yes.
All right. There is a the 9mm that you talked about, that you own, do you have a CCW?
Yes.
Did you have the gun with you on this weekend?
Yes.
Where was the gun?
In the center console.
Is that somewhere that you usually kept it?
Yes.
Did the gun have a trigger lock on it?
No.
Do you know if the safety was on?
No.
No, as in it wasn't on, or you don't remember?
I don't remember.
Would it be your habit to keep it on or not on? Do you remember?
No.
All right. Was the gun in a case of some sort that was locked?
No.
Where was the gun was in a center console. There was testimony about a holster that was purchased. Did you purchase a holster with this gun?
Yes.
Was the gun in the holster in the center console?
Yes.
So tell us about the drive home. What's the mood like in the car?
It was pretty silent. She never said a word.
The whole drive back?
Yes.
Were you trying to talk to her, and, cheer her up or anything like that?
No.
Were you listening to the radio?
Yeah.
So what happens as you're getting closer to climbing?
As we got closer, I noticed she had the gun.
How did you notice? Let me stop you there. You said as you got closer, you remember where you were? Like what road you were on?
On Highway M.
Okay, is Highway M, is it accurate to say that that's between Watertown and Clyman?
Yes.
Okay, and you say you noticed that she had the gun. How did you notice this?
I seen it in her hands.
Okay, what happens?
She reached up and that was it.
Do you remember what hand it was with?
Her right.
Okay, now you're driving, it's fair to say, and you're looking forward. Were you turning to your right and seeing this as it was happening, or did you catch it out of the side of your eye?
I caught it off the side of my eye.
And what happened?
I heard the gun go off.
Was it loud?
Yes. My ears were ringing.
Okay. What happened to Crystal?
She was slumped over.
How far away were you from Clyman?
About 10 miles.
What was going through your mind?
I was shocked.
Was she, I see this, now there's a medical center in Watertown. How did she appear? Did she appear as she died instantly, or that there was some some treatment that could happen to help her?
I don't think so.
Why do you say that?
She wasn't moving.
Was she wearing her seatbelt?
Yes.
Was her seatbelt holding her up?
Yes.
When you say she was slumped, do you remember if she was slumped forward, to the side?
It was forward.
Do you remember what hand she had the gun in?
Her right.
Okay. What did you do?
I went to my parents' place.
Why did you do that?
I was scared.
Scared about-
Panicked.
Why?
It was my gun.
Anything else?
I was the last one to see her alive.
Did you think you were going to be blamed for her death?
Yes.
Were you thinking about the divorce proceedings?
No.
What did you do when you got to your place, your home?
I just stood outside the vehicle for a little bit.
What's going through your mind?
I was just shocked.
What did you do?
I took her and I laid her in the grass.
Do you remember where you parked at your parents' place?
Yeah, behind the red torrent.
You laid her in the grass and you opened the door and unbuckled her and put her in the grass?
Yes.
What did you do then?
I burned her
Where?
in the grass.
There was some images of a burn area that we saw on direct testimony, which is to the right of the driveway behind some garden sheds. Is that where it was?
Yes.
Okay. Why didn't you at this point call the police?
I thought I'd get in trouble. I panicked.
How long did you burn her for?
It's like 4 hours.
And after that time period, it appeared that she was mostly gone.
Yes.
Later that evening, you went to Juneau, correct?
Yes.
You used her bank card to check an account balance, is that right?
Yes.
Okay, now that's something that you admit you did, correct?
Yes.
I want to ask you about some of the Google searches that were on your phone. There were some Google searches in like early February where you said, "Can infidelity hurt you in a divorce in Wisconsin?" Did you Google that?
Yes.
And there was another one about cheating spouse and divorce on February 2nd. Did you Google that?
Yes.
Okay. Why were you Googling those items in February of
I thought she was
2024?
messing around.
You thought she was seeing somebody else?
Yeah.
You also Googled about installing cameras in a divorce on March 15th, right?
Yes.
Why did you do that?
Her dad was putting up cameras
Where?
on the house.
You were looking to see if he was able to do that?
Yes.
There was also, at this point, you had, well, in June, you had the pending termination of parental rights case happening. Is that right? There was
Yes.
a trial coming up?
Yes.
There were some Google searches about, can a disability person be put on the witness stand? Do I have to testify if I'm mentally unstable? Can your past record be used against you in a jury trial? Why did you Google that?
For Crystal.
On June 7th, you Googled, do dogs attempt suicide? Why did you Google that?
My dog was hit by a car.
And you thought for some reason your dog tried to kill herself, or?
She ran right in front of the vehicle. I seen the whole thing.
What was your dog's name?
Missy.
You Googled about widow's benefits. Specifically, can you get widow's benefits if taxes never filed on June 6? And how long can you get widow's benefits, also on June 6? Tell us about that Google search.
Well, she was curious. Crystal was curious because her mom was getting widow's benefits, and she waited like 2 years to file for it.
How do you know that?
Crystal said so.
And you said that if taxes never filed, why were you adding that to it?
Because her husband never worked. He only did mowing jobs.
You talking about Brenda Acosta's husband?
Yes.
And to your knowledge, was he deceased?
Yes.
Did Crystal show you any documentation about the widow's benefits or anything like that?
No.
All right. The firearm that you purchased in the spring of 2024, You also had some searches for a silencer in February, and then in April, a Taurus G2C silencer and a homemade silencer, both on April 8th. Did you do those Google searches?
Yes.
Why'd you do that?
I was just curious.
Did you ever buy a silencer?
No.
Did you ever try to make a homemade silencer?
No.
Now, aside from the firearm and the holster, did you also purchase a gun cleaning kit?
Yes.
Did you buy anything else related to the gun? I guess ammunition?
Yes.
Okay, anything else?
A case.
What do you mean by a case?
A plastic case.
Okay, that you put all the items, the gun, the holster inside it?
Yes.
Okay. We saw you got your CCW, correct?
Yes.
Did Crystal get her CCW?
Not that I'm aware of.
She ever talk about getting a CCW?
She wanted me to send it in for her.
Okay. Did you guys, did she take any classes?
Yes.
Okay, tell us about that.
We took a class together.
Do you remember where it was?
Moose's Lodge.
Do you remember when it was?
No.
It was sometime in the spring of 2024?
Yes.
Tell us about the class. Like what, you come in and what do they teach you?
Just the safety of a gun.
Do you remember how long the class lasted?
It was like an hour and a half.
Did both you and Crystal attend the class?
Yes.
There was some Google searches about can you track someone's cell phone in March 30, what's an IP address on April 4th, can police track your location on April 4th, and other questions on April 4th about IP addresses. Why were you Googling those items?
A friend of mine told me that they'd be traced.
What could be traced?
IP addresses.
Did you know what an IP address is?
No.
Did you find out what it was?
Not really.
What's to the best of your knowledge? What do you remember about that search?
Just that it could be traced.
Then in the April 12th, there were some Google searches about death. One was, can a person feel when they're dying? That was on April 12th. And that was brought out during the prosecution's case. It was at a time that you were also looking at CCAP court records for your termination of parental rights case. What's going on with you?
I was thinking about shooting myself.
Committing suicide?
Yes.
Why?
Just everything was depressing.
What was depressing for you?
Losing the kids.
Anything else?
No.
Did also other searches on May 28th, the difference between a head and chest shot? Do you die instantly from a gunshot to the head? A gunshot to the head, instant death. And then will a 9mm shot to the head kill an animal? Those were all on May 28th. So this was about 6 weeks after the first one. What were those Google searches about?
I was thinking about committing suicide again.
Tell us about your living situation at this time. You're living with your parents?
Yes.
You know, how was that?
Stressful.
Why?
It's a dirty environment.
Okay, we saw pictures of your parents, the parents' home and your home, the N3251. And we saw plenty of boxes and things piled high inside the home. Was that generally how the home looked?
Yes.
Was it always like that?
Yes.
Was it ever clean in some regards?
No.
Okay, so at this point, you're going through a divorce. You've lost your children or about to lose them permanently. were you working at the time?
No.
Do you remember when the last time you worked before that?
It was like March.
Then some of the Google searches, there was one on June 6th and June 10th, child custody lawyers in Milwaukee. Is that something you looked up?
Yes.
Why is that?
Because we were going to go see one of the lawyers.
Okay, so June 6th is 2 days before you picked up Crystal on June 8th. Was it something, why were you Googling that a couple of days before seeing Crystal?
We were talking about it.
Okay. On June 10th, there was also a Google search for Milwaukee, Hange, and Huneke. Was that a law firm you looked up?
Yes.
So that was on June 10th when you were with Crystal. Is that right?
Yes.
Were you looking them up at the same time?
Yes.
And then on June 11th, there was a Google search for, will a 9mm kill an animal if shot in the head? What was that Google search about?
If it would kill an animal.
Okay. Would you have concerns about animals when you were camping, or
Yeah.
what animals? Like at the Adams County area?
Yeah.
Okay. Then there was a Google search on June 11th for 5217 South 51st Street in Greenfield. Is that one of the lawyer's addresses?
I think so.
And then there was also one on June 11th at Constantakis Law Office. Was that also one?
Yes.
Okay. There was some evidence presented on direct testimony about Facebook messages. Now, did you create a fake Facebook account saying it was Crystal?
Yes.
Okay, why were you doing that?
Trying to get people to back off a little bit.
What type of people?
Her family.
Did you want to make it just seem that she was still alive?
Yes.
You know that's something that wasn't going to last forever, right?
Yes.
Okay, but were you the one that sent out the fake messages?
Yes.
After Crystal died, what did you do with your firearm?
I put it in the bedroom.
Did you clean it?
No.
Was that the firearm that was ultimately recovered by law enforcement?
Yes.
In the vehicle, did you find a bullet casing?
No.
Did you look for one?
No.
What did you do with her phone?
I threw it away.
Do you remember when you threw it away?
Not offhand.
On June 24th, you had a sheriff's deputy come to your property.
Yes.
Okay, later that night, did you take the Mitsubishi Eclipse up north?
Not till the next day.
Why did you do that?
To hide it.
Were you scared of being accused of killing Crystal?
Yes.
Did you also, there were a number of purchases that were done with Crystal's card, like the sulfuric acid, like the Drano, headlights, and other things, cash withdrawals. Was that all you?
Yes.
What did you do with the sulfuric acid?
I dumped it over a burn pit.
Was that an attempt to get rid of any evidence of her body?
Yes.
You gave a Mirandai statement on June 26, 2024. There was Detective Contney and there was another detective there.
Yes.
Okay. Were you honest with them?
No.
I guess it's fair to say that some of the things you said were truthful?
Yeah, some of the things were,
Okay, but the vast majority of that, was it not true?
yes.
Okay, why were you lying to these detectives about what happened to Crystal? I mean, why didn't you just tell them, look, we were in the car and she had the gun and it went off?
I was scared.
You're scared of that you were going to get blamed for her death?
Yes.
Okay. Thank you, Mr. Rasch.
We take our morning break. I just would like to get a few things, exhibits together, please.
Good. All right, we'll take 15 minutes.
Do you want this, Andrew?
Ready?
Now, maybe, is your mic on? Maybe that's what's drawing the feedback. Very well.
Good morning, Mr. Rasch.
Good morning.
So you said you were born in Dodge County here, correct?
Yes.
Lifetime resident, right?
Yes.
And where did you go to high school?
Dodgeland.
Dodgeland? You met Crystal in 2008, correct?
Yes.
And you were married prior to that, though, correct?
No.
You were not married prior to that. Did you have children, though, prior to meeting Crystal?
Yes.
And you have 2 adult children in addition to the 4 children that you mentioned before, correct?
Yes.
And you still have a relationship with those children, is that accurate?
Yes.
That's Zach Jr., correct?
Yes.
And how old is he?
20.
20, and Hope, right?
Yes.
And where does Zach Jr. live?
Minnesota.
And where does Hope live?
Wisconsin Rapids.
And how old is Hope?
25.
And does Hope have children?
Yes.
Okay, and Crystal knew Hope and had a relationship with her, and Hope sent her pictures of her kids, things like that, correct?
Yes.
And you regularly kept in contact, messaging those 2 adult children, correct?
Yes.
And so then you said when you got married to Crystal in 2013, correct?
Yes.
Where did you guys get married?
Here at the courthouse.
And then did you have a reception or something afterwards?
A little get together.
Okay, did her family attend?
Just her grandparents.
Just the grandparents,
Yes.
not her parents?
No.
Did you have a good relationship with her parents?
No.
Never a good relationship?
No.
She had siblings too, right? April and Chris, I think, right?
Yes.
Did you have a good relationship with her siblings?
No.
Did you have a good relationship with any of Crystal's friends?
She never.
Working now? Did you have a good relationship with any of Crystal's friends?
Yes.
So what friends did you have a good relationship with?
It would have been Doug Goller.
Okay, Doug.
That's the only one I could remember.
So one of her friends, just Doug.
Yeah.
Okay. But none of her other friends, correct?
No.
Okay. So then in 2013, when you first got married, you lived with her parents at the Wood Road address. Is that accurate?
My parents.
I'm sorry, yes, your parents. Was the house the same, that same residence that we saw in the photos previously?
Yes.
And same sort of plot of land, correct?
Yes.
Because that was your grandparents' land originally that they had given to your parents, correct?
Yes.
And then eventually you and Crystal moved to that Main Street address, correct?
Yes.
And what year did you move to that address, if you can remember?
I think it was 2014.
2014, okay, so about a year after getting married.
Yes.
And were you working then?
Yes.
Where were you working?
Richelieu.
Richelieu?
Yeah.
Okay, and that's in, remind me, in Beaver Dam. How long did you work there?
Almost 2 years.
2 years, okay. Now, at some point, Crystal filed for divorce in 2018, correct?
Yes.
And during that time in 2018, CPS was involved in that first divorce, correct?
I'm not sure.
If I told you that the notes and the court record indicate that the CPS was involved, appeared at the court appearance, would you say that that was accurate?
Pretty much.
Okay. And that there was originally a petition in that divorce case to give Crystal sole legal custody of the children, correct?
Objection relevance, Your Honor.
I think it's directly there. So overruled means you can answer. So there was in that original divorce case in 2018, there was a petition to give Crystal sole legal custody of the children. Is that accurate?
I'm not sure.
But if I told you that the notes and the Wisconsin Circuit Court access records indicate that there was a petition filed to give Crystal sole legal custody in that case, would you say that was correct?
Objection, Your Honor. It seems facts not into evidence and counsel's testifying.
Overruled.
I'm not sure.
Okay. During that divorce, did Crystal move out of the marital home?
Yes.
She moved to Beaver Dam, correct?
Yes.
Okay. Did she get an apartment?
Yes.
And then looks like sometime in January of 2019, she moved back to that Main Street address, correct?
Yes.
Now, was it around that time that Crystal went up to Michigan? The first time?
I don't remember.
You don't remember, but you said when you were talking with Deputy Kukan that she does this all the time. She leaves and she goes up to Michigan, correct? You said that to Deputy Kukan.
Yes.
And in fact, that she had gone up to Michigan during the filing of that last divorce in 2018. That's correct.
Yes.
And you went up to Michigan to get her, correct?
Yes.
And she was with her family, April, I believe either April or Chris up in Michigan, correct?
Yes.
So she didn't run away from her family. She left you to go up to Michigan, correct?
Yes.
So when you told that information to Deputy Kukan about her leaving, that was a lie, correct?
Yes.
She just left you, correct?
Yes.
And after you went up and got her from Michigan, sometime after that, the divorce was dismissed, correct?
Yes.
And she was the person who originally petitioned for divorce, correct?
Yes.
And then it was sometime after that 2018 divorce was dismissed that CPS filed the termination of parental rights, correct? Or that the Dodge County filed that. It's the Corporation Council filed, correct?
Yes.
After that filing of the termination of parental rights, how many times did you see your children after that?
Once.
One time. Supervised or unsupervised?
Supervised.
What year was that you saw them?
2019.
2019. So Approximately how long after the termination of parental rights was filed did you see the children?
None.
So let me rephrase the question, because you just said once, so I want to make sure that we get this right. There was originally a filing, maybe something before the termination of parental rights. So the Corporation Counsel got involved in the case, and you weren't allowed to have unsupervised contact with the kids, correct?
Yes.
But you were allowed to have supervised contact with a social worker present, correct?
No.
Or someone else present, another adult present, you were allowed to have supervised contact.
No.
You weren't allowed to have any contact.
No.
None whatsoever with any of the children.
None.
So after Dodge County got involved, you never saw the kids.
No.
Okay, so when you said before once that you saw them once, did I misunderstand you?
No, I seen him once with Crystal.
With Crystal. Did the county know about that?
They were supervising.
The county was supervising.
Yes.
Okay, so can you just maybe expound upon that, explain that to me? When did that happen?
In 2019.
So 2019, was that after the county got involved and filed legal paperwork, the termination?
It was before.
Before. And that was the only time that you saw your children with Crystal?
Yes.
Did you ever see your children after that time?
No.
But Crystal continued to maintain contact with the children, correct?
Yes.
Is it fair to say that primarily the reason why she could not have unsupervised contact with the children is because she was maintaining a relationship with you?
Objection, Your Honor, calls for speculation.
Sustained.
So I want to move on to the filing of the second divorce. That divorce happened in September of 2023, correct?
Yes.
And you had a lawyer and Crystal had a lawyer, correct?
Yes.
And you said it didn't really affect anything at all, though, correct?
Yes.
But you had to move out of the marital home, right?
Yes.
That wasn't an option. You had to do that by court order, correct?
Yes.
And then at some point in October, Crystal told you to stop contacting her, correct?
No.
No, she never sent you any messages from her phone in October of 2023 telling you to stop contacting her.
No.
Never.
No.
So she said, stop messaging me on Messenger and saying all this stuff to me, and seriously, I don't get what you are trying to do. I don't know how you think your marriage is going to stay and stuff. Man, there's a lot of reasons why I'm done. And yeah, you can say that I'm this and I'm that to you, but I don't care because I can't believe you anymore. I can't. She never sent that message to you?
I don't remember.
You don't remember.
No.
But if I told you that I got that message off of your device, do you think that would be accurate?
Yes.
And that was from her phone number that you saved as my wife?
Yes.
Okay. So now would you like to change that answer that she messaged you and said stop contacting me?
Yes.
So she did, in fact, tell you to stop contacting her.
Yes.
And at some point, she blocked you with her actual phone number, correct?
No, not that I'm aware of.
So you could not send her messages to her phone number, right? When you sent her messages to her actual phone number, you got no response, correct?
Yes.
That's accurate, correct?
Yes.
And you told law enforcement that you don't have her phone number, correct?
Yes.
And you told them that because when you sent her messages, she would never respond when you sent messages to her phone number, correct?
Yes.
So you had to message her other ways, correct?
Yes.
And you started messaging her through Facebook.
Yes.
right?
Yes.
And there were times even then where she didn't want to talk to you. Just even that message says, stop messaging me through Messenger, correct?
Yes.
So this was not some just like easy, easygoing divorce where it's just like, oh no, everything was just the same. You had to move out. She didn't want to talk to you, correct?
She just came over to talk.
She came over to talk, but you would ask her to come over to talk, correct?
No.
And you never asked her to come over to talk.
No.
You never asked her out for dinner. You never tried to take her to the Olive Garden. You never tried to take her out to eat.
Objection compound, Your Honor.
I'll wait till he answers. I apologize. Did you ever try to take her out to eat?
We decided together to go out to eat.
She decided together. You were never the one that initiated those messages.
No.
Never. So there was never a discussion about money, and you never said, do you want to go out to eat? And she never said to you, why are you doing this? And you never said, you said you needed money, I'm trying to take you out to eat. That never happened.
I don't remember.
You don't remember. Okay. How many times after she filed for divorce, she filed for divorce in September, and then you would have winterized that camping spot, correct?
Yes.
And then you would have gone up and went camping together over the Memorial Day holiday, is that correct?
Yes.
So the end of May, do you know what day you came back? On Monday, Tuesday, something else?
I think it was Tuesday.
Was the rest of your family present on that trip?
Yes.
Who was present?
My parents, my son.
Did your son have a camper up there?
I gave him one, my old one.
Okay, so in your previous testimony, you said your aunt, your uncle, and your parents had a camper, but you left out your son having a camper up there. So your son also had a camper, right?
Yes.
Anybody else you left out during your direct testimony that had a camper up there?
No.
Okay. So then you, on the 8th, make plans to go up to the Dells. How did you make those plans?
Through Facebook.
Through Facebook Messenger.
Yes.
And this time, was there going to be anybody up there?
No.
Just the two of you?
Yes.
And you were going to pick her up at that church parking lot, correct?
Yes.
And that was, according to your statement anyway, her idea that you pick up in that church parking lot, correct?
Yes.
Okay. And is that in part because she didn't want her family to know that she was spending time with you? Is that accurate?
Yes.
Because her family didn't like you?
Objection calls for speculation.
Overruled, if you know.
So you can, overruled means you can answer.
All right.
Correct. Her family didn't like you.
Yes.
And she also didn't tell her friends that she was going camping with you, correct?
No.
Because her friends did not like you.
Correct.
And they didn't
Objection
want.
vague is which friends, Your Honor.
Sustained.
So did her friend Robin like you?
No.
And did any of her other friends, I think you talked about in the statement, Jessica and Antonio from Wendy's, did they like you?
No.
So she wouldn't tell them about hanging out with you because they didn't want her hanging out with you. Is that correct?
Objection calls for speculation.
If you know.
Sustained.
Okay. So you pick her up on the 8th, and you talk about this to law enforcement, correct?
Yes.
And in your statement to law enforcement, you initially tell them that you picked her up on the 8th, and then you came down You went up there, walked along the strip, and then you came back the same night. Did you tell law enforcement the truth during that statement about what you did on the 8th?
No.
So you lied to law enforcement during your initial statement about what you did on the 8th, correct?
Yes.
Okay. I just want to go back very briefly. Also in that statement, in the initial interview, in the beginning of the interview, you said that you didn't know any of Crystal's friends, correct?
Yes.
But that was a lie, correct?
Yes.
You knew Jessica, correct?
Yes.
And you knew Antonio, correct?
I didn't know him directly.
But you knew of him.
Yes.
And you knew at least of Robin.
Yes.
And then during your testimony here, you talked about going to Denny's. And is that Denny's, help me understand, where is that Denny's located?
Wisconsin Rapids.
Okay. So you went to Denny's on the 8th or another day?
I think it was another day.
Okay, so in your statement here in court, you even kind of messed up what restaurant you went to on the 8th, right? Because in your interview, you told law enforcement that you guys got like an elephant ear and cheese curds that you were eating down on the strip. Is that correct?
Yes.
So which one is true? Help me understand.
The one with the Denny's.
The Denny's. So you lied to law enforcement about where you ate even on the 8th.
Yes.
Okay. So then you testified on the stand that after walking along on the strip, you guys went back to the camper and went to bed. And I think we already touched upon that originally with law enforcement, you said you stayed on the strip late and then went back to Kleiman. You dropped her off at the church parking lot, and that was a lie. And we already established that, correct?
Yes.
So now we're moving on to June 9th. Is it fair to say that it took about 3 hours into your interview for you to tell law enforcement that June 9th even existed? Is that
Yes.
accurate?
Yes.
And then you said on June 9th, that's the day that you went to these flea markets?
Yes.
Okay. And where were the flea markets again?
In Adams.
In Adams, okay. And you went to the flea markets all day on Sunday, June 9th?
Not all day.
Okay, so what did you do? And then you went to Ray's Closeouts. I guess that's not a flea market, but it's a discount store, correct?
Yes.
And those flea markets are on that main strip of, is that in like the township of Adams?
Yes.
Okay. And then you said that at Ray's Closeout, Crystal bought some toys. Is that correct?
Yes.
And what toys did you buy? Or did she buy? Do you remember?
No, I don't remember.
Okay. So what happened to those toys?
I don't know.
Oh, did you burn those?
No.
Oh, you didn't burn those. Were those just in your house somewhere?
No.
No. So what happened to them?
They should have been in the vehicle.
In the Mitsubishi?
Yes.
Toys in the Mitsubishi.
Yes.
So what kind of toys? Like toys for little kids, for bigger kids?
For little kids.
For little kids, like toddlers or 5-year-olds, 6-year-olds?
Oh, 6. Nope.
So like a stuffed animal?
No, they're just like little toys.
Little toys.
Yeah.
Okay, and where do you think those would have been in the Mitsubishi?
In the back seat.
In the back seat of the Mitsubishi. Okay? So, and then you, on the 10th, help me understand, what did you do on the 10th again? You went back to the Dells?
Yes.
To the strip?
Yes.
All day or just in the morning or something else?
That was in the evening.
So what did you do in the morning on the 10th?
We went to the Rapids.
You went back to Wisconsin Rapids to flea markets, something else?
To look at a house.
Oh, I'm sorry. Thank you for reminding me of that. To look at the house. So do you know the name of the realtor that you looked at the house with?
No, I do not.
So did that realtor, so I've gone house shopping before, and my realtor always gave me this sheet of paper, and it had a bunch of pictures of the house that were printed out on it, and then it had these handwritten details about the house, like spectacular 4-bedroom house, 2 bathrooms, remodeled kitchen, new countertops. Then it had the tax information and any inspection information. Did you get any of that from that realtor?
No, I did not.
Oh, you didn't get any of that. Okay. So that realtor did not print out any of that information.
No.
Did that realtor give you a card?
No.
So this realtor, you book an appointment with this realtor to look at that house, and that realtor gives you no information.
Objection, Your Honor, misstates the testimony. There was no testimony that he made in any.
Overruled. Cross, go ahead.
The realtor gave you no information.
No.
And you can't remember the realtor's name, correct?
Correct.
Male or female?
Female.
Old, young,
Middle-aged.
middle-aged? What does that mean? 30, 40?
Probably in her 30s.
Okay, 30s. Dark hair, blonde hair, brown hair,
Dark.
dark hair. Anything else you can remember about her?
No.
Nothing else that you can remember about her, okay? So then, and I think, did you say that you went to one house on Sunday and then one house on Monday?
Yes.
But in your interview, you said you went to both of those houses on Sunday, right?
I do not remember.
You don't remember. So which one is the truth? The one that you said in the interview or the one here on the stand?
The one here.
The one here, okay. So if things are different, the truth is on the stand and you were lying to law enforcement.
Objection, argumentative.
Sustained.
So the one that you went to on Sunday or Monday, did you get any information about the house?
No.
Neither time.
Neither.
Okay. And do you remember the street address of the house?
No.
The listing price of the house?
They're both over 100,000.
Over 100, over 200, something else.
Just a little over 200.
Just a little
For
over
one.
over 200. And the actual, is Wisconsin Rapids a city, village, town, something else? If you know.
I think it's just a town.
And was it in Wisconsin Rapids proper, or like, for example, Kleiman, you have the actual village of Kleiman, and then there's like the township of Kleiman. So it was the Wisconsin Rapids proper, or sort of the outskirts of Wisconsin Rapids?
It was inside.
And then like the proper part of Wisconsin Rapids?
Yes.
And was it by anything?
One was by a jail.
One was by a jail. And was that the Sunday or Monday house?
Sunday.
The Sunday house. What about the Monday house?
I don't remember what that was by.
You don't remember what that was by?
No.
Okay. And I think that day you also said you went to Taco John's,
Yes.
and that was before you went to the house.
Yes.
And the Taco John's, that's also in Wisconsin Rapids?
Yes.
Okay. And you went to the vape store as well, correct?
Yes.
And that's also in Wisconsin Rapids?
Yes.
Okay. Now, in your interview, is it fair to say that it took several hours for you to even admit that you ever went to Wisconsin Rapids with Crystal?
Yes.
That it wasn't until I think they actually confronted you with Crystal's bank statements that she had transactions from Wisconsin Rapids that you finally admitted going to Wisconsin Rapids with her. Is that accurate?
Yes.
Okay. Now, you then talk about going to Dollar Tree. Crystal got some paper towels and things like that. Then you talk about, again, that you went back to the strip at the Dells, and you were present for the testimony for Brad Conkle, correct?
Yes,
And you're saying that this was on Monday, June 10th, that you went back to the downtown area of the Dells, correct?
yes,
And you would agree, though, that there's nothing on the flock. The flock just only puts you in Mauston on Monday, June 10th, correct?
yes,
So it looks like Highway 82 and Power Street at 5:24 p.m., 5:26 p.m., and then Highway 82 and I-90 at 5:32 p.m., but never puts you at that main intersection of the Dells that we saw on some of the previous slides, correct?
correct.
Okay. So then you said, you talked about Crystal practicing shooting the 9mm with you. When did she start practicing shooting guns with you? Just right in February?
No,
Okay, so when did you own a gun before that?
it's been many years.
Okay, so when was the last time? Okay, because you purchased this 9mm February 20th, right?
Yes,
And so the camping land would have been winterized, correct?
yes,
So you wouldn't have been going up to Adams County to practice shooting, correct?
no.
Okay, so when did you own a gun before that?
It was many years ago.
Many years ago. So like the many years that you talked about in your interview, help me understand when you purchased a gun in the past.
It was like in the 2000s,
2000s, like 2001, 2002,
something like that.
okay. And what kind of gun did you purchase?
A 22.
Okay, so but you and Crystal got married in 2013, right?
Yes,
So you had that gun, you're saying when you guys got married.
no.
You didn't, so what happened? So how could you, if you didn't have the gun, how could you guys go practice shooting with it? I'm confused.
Not that gun she didn't shoot.
Okay, so what gun did she shoot with?
The 9mm.
The 9mm that you bought in February?
Yes,
Where did you, you testified though that you practiced shooting with that on the Adams County land, right?
yes.
Okay, so when did you practice shooting with that gun on the Adams County land?
Memorial weekend.
Memorial weekend. So who observed that?
My family,
Your family. Who?
my mom,
Your mom
yes, my son,
and your son. Anybody else?
no.
So if I told you that law enforcement interviewed those people and they never said that they...
Objection, Your Honor, introducing facts outside the evidence presented, introduction of hearsay.
It's cross-examination.
Overruled. Go ahead.
So if I told you that law enforcement interviewed those people and that those, first of all, that Zach Jr. told law enforcement that he wasn't even allowed to touch your gun.
Objection, Your Honor. Asking for, the question involves hearsay and confrontation.
Overruled.
So I'll say that question again. Zach Jr. told law enforcement that he wasn't even allowed to hold your gun. Do you think was that inaccurate?
That's inaccurate.
That's inaccurate. So, and Zach Jr. never told law enforcement that he observed Crystal firing a gun.
Objection, Your Honor, calls for speculation.
Overruled.
Was that inaccurate?
That's inaccurate too.
Okay. And your mom was interviewed and she never told law enforcement about observing Crystal firing a gun.
Objection, Your Honor, same objection, hearsay, confrontation.
Overruled.
That's inaccurate.
Okay. So was there any other time that Crystal shot that firearm up on the Adams County land?
No.
So just that one time in Memorial Day.
Yes.
And then, so not during the CCW class that she took with you.
No.
Okay. So then you testified here about, at some point, you leave Adams County, right, and start coming down to first the Oconomowoc area, right?
Yes.
So help me understand, was the plan all along to go to the attorney's office in Milwaukee?
Yes.
And so you decided to stop along the way in Oconomowoc at that Goodwill?
It was Culver's first.
Culver's first. So you stopped in Oconomowoc because of Culver's.
Yes.
Okay. And then decided to stop at Goodwill.
Yes.
And then did Crystal purchase another shirt there?
Yes.
And was that like a t-shirt or something?
Yes.
And then she changed into that in the back seat, right?
Standing outside the vehicle, she changed it.
Standing outside the vehicle, thank you. And then she put that sweatshirt in the back seat, correct?
Yes.
And so all this time your gun was in the center console. Is that accurate?
That I recall of.
That you recall. You didn't have it on your person in the holster because you would have been allowed to like carry, conceal, have your t-shirt over it, right, with your CCW
Yes.
permit, but you were not carrying it at that point.
No.
It was just in the center console of your vehicle, correct?
That I know of.
Was there a gun case in the back of the Mitsubishi?
Yes.
So how come you had the gun case along with you?
I'm not sure.
You're not sure, okay. So you stop at the Culver's, and you paid for that, right?
Yes.
And then you went to the Goodwill, and Crystal paid for that, correct?
Yes.
And in fact, she used her card for that transaction, right?
Yes.
Okay. And so then you got back on the road to go down to Milwaukee, correct?
Yes.
And you're saying that was Crystal's idea, correct?
Yes.
And then at some point, she gets mad because she can't meet with an attorney.
Yes.
Okay, and was she looking up attorneys on her phone too, or you guys were just using your phone?
I'm not sure if she was looking any up.
Okay. And so then you decide to just leave Milwaukee, right?
Yes.
And then did you stop anywhere on the way home?
No.
No. But you told law enforcement that you stopped at a speedway, right?
That was before.
Before going to Milwaukee?
Yes.
So what time did you go to the lawyer's office?
I think it was like around 3.
Around 3.
2 or 3.
2 or 3. So if I told you that your cell phone mapping had you in the Greenfield area, around the area of the residence, or around the area of the lawyer's offices just before 2 o'clock, would you say that that was accurate?
Yes.
And then if we had you on video going into the speedway just on the edge of New Berlin at 2 o'clock, would you say that was accurate?
Yes.
So it seems like and then New Berlin is west of the Greenfield area where you were going to the lawyer's offices, correct?
Yes.
So it seems like you went to the speedway afterwards, correct?
Before.
Before, okay. But in your interview with law enforcement, you told them that you went to the speedway afterwards, correct?
Yes.
But that was a lie to law enforcement. You went to the speedway before.
Yes.
Okay. So then you said you were driving home. It was quiet in the car. You were listening to the radio. Do you remember what you were listening to?
No.
You're listening to music,
Yeah.
but you don't remember what kind of music.
No.
Like the radio or something off of your phone or something else?
It was the radio.
The radio, do you have a favorite station that you always listen to?
No.
No? Okay. And then, so do you remember what route you took home?
Not offhand.
Okay. How did you know how to get home from Milwaukee?
GPS.
So you typed it into your GPS. Did you type something specific into your GPS?
think the 730 Main Street.
730 Main Street. So that's her address, right?
Yes.
But you never dropped her off at home, right?
No.
You would only drop her off at the church, correct?
Yes.
Did you type in anything? I guess it was how to get to Milwaukee without interstates, correct?
Yes.
Do you have some setting in your phone how to get home without going on the interstate?
I think so.
Okay. But so sitting here, you don't know what route you took.
No.
Okay. So you said you're traveling home, and then at some point you're on Highway M, correct?
Yes.
And then when does she have the gun in her hand?
Went on Highway M.
So at what point does she reach into the center console?
She didn't reach into the center console.
How does she get the gun in her hand?
She had it beforehand.
Okay, so then help me understand that. When does she get the gun in her hand?
On County M.
On County M. Okay, so when does she reach into the center console?
She had it out of the center console beforehand.
When?
I'm not sure when she took it out.
So you're driving down and you don't notice when she opens the center console and pulls your gun out.
She had it before.
Before when? So like you think well before M? I'm just trying to understand.
Yeah, well
So
before.
M like in Watertown, or M as you're getting closer to Kleiman, or something else?
She took it out beforehand.
Before M? So where did she take it out of the center console?
I'm not sure when she took it out.
Because when you're driving, so you would have had to be on Highway 16, right?
Yes.
So Highway 16, and then you kind of have to, there's a quick trip, and then you have to turn, I think it's R, and then on Juneau Road, and then you get onto M, right?
Yes.
And there's a couple stoplights there, so you're sort of slowing down in that area, especially on that Juneau Road where you go by that graveyard. That's a pretty narrow road, and you can't go, I mean, I guess you could go 45 miles per hour, but it's pretty narrow, correct?
Yes.
So did she have the gun before or after that point?
I'm not sure when she took it out of the center console.
So you have no idea when she took it out?
No.
Objection, Your Honor, asked and answered.
I'm just trying to understand his testimony.
He answered, he
Overruled.
doesn't know.
So once you notice that she has the gun, what is she doing with it?
She's holding on to it
Holding onto it how?
with her right hand.
Okay, so she's within the holster, out of the holster.
Out of it.
So she's removed it from the holster. Do you know when she took it out of the holster?
No.
But you know that she has it in her right hand.
Yes.
So when did you know, at one point did you notice that she had it in her right hand?
On M.
On M. So on M right when you get off of Juneau, or further up M?
A little bit further up.
Okay, so there's, I think on the left-hand side, there's some barns, and then you keep going and just fields. Like what point on M? Do you know the cross streets, or how far you were from Kleiman when you noticed that she had it in her right hand?
It was about 10 miles.
10 miles, okay. So 10 miles from Kleiman, she has the gun in her right hand. Does she say anything?
No.
And this whole time, she never said one thing.
No.
So she just takes the gun out of the center console, has it in her right hand, says nothing, and then what?
She shoots herself.
She shoots herself. Do you know where she shoots herself? Front of the head, side of the head, back of the head?
On the side.
The side, here. So you see her, how do you know that? So you didn't know when she took it out of the center console. You don't know when exactly she took it out of the holster, but you know that she put it up to her temple, right?
Not exactly sure exactly where.
So you don't know, so you just know right side.
Yes.
So you don't know if it's on her jaw or her ear or her temple or something else. But you know it's on her right side.
Yes.
Where does that happen?
On M.
I keep saying that. Where 10 miles away from
About-
Kleiman?
About 10 miles.
About 10 miles, okay. This is sort of like, I don't know where Crystal is, right? Same phrase
Objection
over and over
argumentative,
again, right?
Your Honor.
Sustained.
So then what do? Do you stop? Do you slow down? Do you speed up? Something else?
I just keep driving.
You just keep driving. You keep driving the speed limit.
Yes.
So no change, no reaction whatsoever. Your wife just shot herself in the head and you don't do anything.
I was in shock.
You were in shock. So then you go home. About what time is this?
I'm not sure what time it was.
Daylight, nighttime, something else?
It's daylight.
Daylight. And then where do you go?
To my parents.
To your parents' house on Wood Road.
Yes.
You go directly there.
Yes.
You don't go to the hospital.
No.
You don't go to the police station.
No.
You don't call 911.
No.
You don't do anything like that, right?
No.
You don't stop at a house nearby and ask for help or anything like that, correct? Go directly to Wood Road.
Yes.
Is anybody home at your house?
Yes.
Who's home at your house?
My mom.
And do you say anything to your mom?
No.
Does your mom come out of the house?
Later on.
So when you first pull into the driveway, your mom does not come out of the house.
No.
So when does your mom come out of the house?
Later on.
Later on when?
In the day.
In the day. What time?
I'm not sure what time it was.
Sun getting close to setting? Not close?
It was probably like an hour afterwards.
An hour afterwards. Is Crystal still in the car at this point?
No.
She's not in the car. So how long after you get in that driveway do you pull Crystal out of the car?
Like 20 minutes.
20 minutes. What are you doing in those 20 minutes?
I was in shock.
You were in shock. Okay. How much blood is there?
Quite a bit.
Quite a bit. Where's the blood?
On her lap.
On her lap. Where else?
I'm not sure where else.
Okay. Where's the gun at this point?
On the floor.
On the floor of the car, front passenger, back passenger, somewhere
Front.
else?
Front.
Front passenger. What do you do with the gun?
I just put it back in the holster.
You put it back in the holster. And is there blood on the gun?
Not that I'm aware of.
Not that you're aware of. So she just shot herself in the head. There's blood all over her. And is there blood all over your car seat?
Yes.
Is there blood on her hand?
No.
No blood on her hand.
No.
So she shot herself in the head, and there's no blood on her hand.
No.
That's okay. And no blood on the gun.
No.
Is there blood coming out of her head?
Yes.
Okay. Blood dripping down the side of the seat?
Yes.
But none gets on the gun, and none gets on her hand.
No.
Okay. And then you pull her out. So where do you park the vehicle?
Behind the red torrent.
Behind the red Torrent. Is that close to that white van that we
Yes.
see in all those pictures?
Yes.
Okay. And then you say that you take her onto the grass. Or the grass where? Where we see all the surface burn area in all the
Yes.
pictures?
Yes.
So there was grass there before
Yes.
until you burned it.
Yes.
So you just drag her down that trail? Is that right?
Pretty much.
Okay. Is she on a tarp or anything like that, or you're just dragging her body down that trail?
No.
So no, she's not on a tarp?
No.
Okay. And then you put her in the grass.
Yes.
And the gun's in the holster.
Yes.
And where does it just goes, you just take it into your bedroom or somewhere else?
I just took it in and put it on the dresser.
On the dresser. And then that's where it stays.
Yes.
You never touch it again.
No.
How does an extra bullet get in the gun then?
I'm not sure.
You're not sure. Okay. So then, let's say this takes an hour or so to get her out of the car. Then you say that, how long do you burn her?
Like 3 to 4 hours.
3 to 4 hours. So in that time, you also decide to message your son, right? Have you seen Crystal?
Yes.
So around 7 o'clock, you message your son, correct?
Yes.
And is that just to kind of take him off the scent that she might be missing?
Something like that.
So, but on June 11th, nobody even has talked to law enforcement or talked to you about Crystal, that Crystal might be missing, correct?
Correct.
And then you also messaged your daughter, have you seen Crystal, correct?
Yes.
And so, and that is because you're panicked, right?
Yes.
Okay. And then, so you burn the body for 4 hours. And then sometime later that night, you start messaging people, women on Facebook, right?
Just as friends.
Just as friends. Okay. And that's sort of in the middle of the night, correct?
Yes.
So you burned her body. So does, in those 4 hours, does the whole body burn up?
Pretty much.
Pretty much the whole body burns up in those 4 hours.
Yes.
So how hot was this fire?
Not very.
Not very hot. And you burned her whole body. Skin. I mean, Crystal, about how much do you think Crystal weighed?
I'm not sure.
You're not sure. So is she like bigger or smaller than me?
Bigger.
Bigger. And I don't want to get, super personal about her, but she was a large-chested woman, correct?
No.
No, she was a small-chested woman?
Yes.
But she did have, I'm going to say that she's fat, but she had skin around her body and her chest area,
A little
right?
bit.
And so you're saying in 4 hours and a not very hot fire that all of her fatty tissue, all of her skin, her thigh bone, her rib bones, her hip bones, all of those things burned up.
Yes.
Did you take a shovel or anything and pulverize those things and pound any of those things?
No.
No, nothing.
No.
Okay. So in those 4 hours, the body is mostly gone. Did you dig a hole later?
No.
Okay. 236. The hole that Andy Rolfs testified to. How did that get there on your property?
I'm not sure.
You're not sure. 235. The fleshy portions of Crystal Rasch that were found in October. How did that get there?
I'm not sure.
Okay. $234. Additional bone and fleshy portion found near that bone. How did that get there?
It was left over.
It was left over. So leftover bone. So now you're saying that was left over. And what did you do with it?
I didn't do anything with it.
You didn't do anything with it. You
No.
just left it on the ground. It was left over in the burn pit.
It was just left there.
It was left there. This area here that was in a hole, these bones that were dug up and sitting on the surface, how did these get there? It was just left over?
Yes.
So really you didn't burn all the body at all, right? There was a lot left over,
A little bit.
okay? And the stuff that was back on the backside of the mound system that was located and back by the shed, how did all those bones get there?
I don't know.
You don't know. So you didn't pick up a shovel and toss those things over there?
No.
No. So the sulfuric acid that you purchased, 32 gallons bottles of sulfuric acid. I think purchased something like 12 bottles of, I think 32 ounces for a total, so 14 32-ounce bottles for a total of 3.5 gallons. You didn't use that at all to pour on her body to help get rid of the body?
No.
No, not at all. You just poured that on top of the burn area later.
Yes.
Okay. So how come you had that Google search later after Kukan visited about sulfuric acid and petrol and the reaction? Why were you concerned about that?
I mixed it together.
You mixed it together. You weren't pouring sulfuric acid on Crystal so that the fats and skin would disintegrate, and then burning that, and then later decide to pour gasoline on top of that to burn the rest of the body because Deputy Kukan interrupted you.
I was burning garbage that day.
You were burning garbage that day, not your wife.
No.
Okay. So, in your testimony, you also talked about some of these searches. You talked about being depressed because you were living with your family in this dirty house. You had your own room, correct?
Yes.
With your own stuff, correct?
Yes.
So I'm going to show you exhibit, and you had access to a washer and dryer, right?
Yes.
And you had your own money, correct?
Yes.
So you had you had the ability to, for example, purchase your own mattress.
That was already there.
But you had the ability to purchase a new mattress if you needed to, correct?
Yes.
And you had the ability to purchase things like sheets, correct?
Yes.
This exhibit that I'm showing you, Exhibit 114, this mattress here with no sheets on it, that's where you were sleeping, right?
Yes.
But you made the choice to sleep in that area, correct?
Yes.
Your parents did not force you to sleep there. Your
No.
mom or your dad didn't come in and dirty that area, correct?
No.
That was your own room,
Yes.
correct? Exhibit 96. This is the area walking into your room, right?
Yes.
That was your room.
Yes.
That wasn't the rest of the house.
No.
So this is the state of your own room and the way that you kept your own room, correct?
Yes.
So this depression about the house being dirty, this is also a state that you put your own room into, correct?
It was already like that when I got there.
But you had the ability to clean it and remove these items, correct?
There was nowhere to go with it.
There was nowhere to go. Well, you could have burned it, right? You were burning things on the 23rd, correct?
It wasn't my stuff.
Wasn't your stuff. So you're saying those items in there weren't your things. So you couldn't burn them or get rid of them or put them in another place in the house.
No, there was no room.
Okay. So, and then you also testified that you were depressed about losing the kids. But you had not seen the kids in 5 years, correct?
Yes.
Had you ever attempted suicide in the 5 years previous?
No.
And on June 11th, the internet search, you talked about that search was about shooting an animal. Is that right?
Yes.
So what animal were you so concerned about that you were going to shoot it on June 11th?
Coyotes.
Coyotes. Why didn't you just try to pour sulfuric acid on them like you were going to do with the gophers?
Objection, argument.
Stand.
Where were the coyotes at in your property?
They're all over.
All over. And so on June 11th, you thought that that time, even though you were fighting over lawyers, that's the time that you needed to Google about coyotes.
You could hear them.
From Milwaukee?
No, from my parents' address.
But that search was at 11:18 in the morning. When you were in Oconomowoc. So why did you need to Google it while you were in Oconomowoc?
I was curious.
Oh, you're curious. Okay, thank you. So these Facebook messages, when you originally started these Facebook messages, you sent Facebook messages to your mom, correct?
Yes.
And you pretended to be Crystal, asking about the red car, correct?
Yes.
And you sent Facebook messages to her friend Robin, correct?
Yes.
and messages to yourself, correct?
Yes.
And did you send any Facebook messages to her parents?
Yes.
And you were saying all of this was because they contacted law enforcement?
Yes.
But the messages that you sent to your kids about whether or not they had heard from Crystal, law enforcement had not even been contacted at that point, correct?
No.
And then I think at some point you sent a message to Hope about Crystal contacting you on Facebook. That message to Hope basically was a lie because Crystal hadn't actually contacted you on Facebook at that point, correct?
Yes.
Okay. Now, with respect to Crystal's phone, you stated you threw that away. Do you remember where you threw that away?
In the garbage.
In the garbage. Do you know where? What garbage?
My parents.
Your parents, like just the garbage that you would tow to the road?
Yes.
Okay. And do you remember what date?
No.
Was it sometime after June 15th?
I think so.
Were you trying to get into the phone prior to that?
No.
Okay. So the Google searches about trying to get into an Android phone, that was not related to Crystal's phone?
No.
Okay. So now I just want to go through a little bit of the interview messages. We went through the interview statements. We went through some of the interview already, but is it fair to say there were a number of lies in the interview, correct?
Yes.
So we talked about lying to Kukan about her prior trip to Michigan, correct?
Yes.
And then I think, did you tell Kukan about the Facebook message too?
No.
No, okay. And then you, in Detective Young's testimony, you also messaged your mom about purchasing some headlights or some LED lights from some woman in Columbus for $25. That was a lie to your mom too, correct?
Yes.
You didn't purchase those from Columbus for $25, correct?
Correct.
You actually bought those at O'Reilly Auto Parts with Crystal's card, correct?
Yes.
And then you also told law enforcement in the account that you worked the 2 weeks prior to June 26th, that you worked every single day, and in fact you had not worked June 24th, correct?
Yes.
So you lied to law enforcement about that date, correct?
Yes.
You did tell them the truth about June 21st, June 20th, and June 19th, correct?
Yes.
And then I think you worked also June 18th, 17th, and 14th, correct?
Yes.
And then June 13th and June 12th, correct?
Yes.
But you also would have told them basically that you worked on June 11th, and that was a lie, correct?
Yes.
And then at some point you would have stated that you worked on Monday, June 10th as well, correct?
Yes.
And that was a lie to law enforcement, correct?
Yes.
And then you also, in the beginning of your interview, told them that when you weren't working those 2 weeks prior, that you would just stay at home and watch TV. You would just be at your parents' house, correct?
Yes.
And that was a lie, correct?
Yes.
In fact, that you were out purchasing items on Crystal's debit card, correct?
Yes.
And that at some point you told them that you drove that blue Dodge Ram up to the Dells on Saturday, June 8th. That was a lie, correct?
Yes.
You were driving that silver Mitsubishi, correct?
Yes.
And even in that conversation, you brought up that fake Facebook account again, correct?
Yes.
And again, that was another lie to law enforcement, correct?
Yes.
We already talked about the fact that you lied to them of not being in Wisconsin Rapids, correct?
Yes.
And then they directly asked you about being at Harbor Freight, but you lied to them about that, correct?
Yes.
You were in fact there on June 15th, correct?
Yes.
Then you asked about going to Menards in the beginning of the interview, and you said it had been a while, maybe Christmas of 2023 or January of 2024. That was a lie, correct?
Yes.
You had just been there on June 23rd to buy 6 32-ounce bottles of Santeen drain cleaner, correct?
Yes.
Then you talked about when the last time was you went to the Watertown Farm and Fleet, and you said 2 months. That was a lie, correct?
Yes.
Then you would say, they would ask you about specific places, and you would say, I just don't remember being there. I don't remember being there. Every time you said that phrase, that was a lie, correct?
Yes.
And then another phrase you would say over and over again with respect to Crystal is, I don't know where she is. That was a lie, correct?
Yes.
Because you did know where she was, correct?
Yes.
And then you stated over and over again that you dropped her off at the church. That was a lie, correct?
Yes.
Then you talked about going to Ace Harbor on June 16th. I'm sorry, they asked you if you had ever been to Ace Harbor. You stated that you don't remember being there. And that was a lie, correct?
Yes.
And then you, when we started talking about the Mitsubishi, for about an hour, so for about, from about 3:40 a.m. to 4:40 a.m., you were talking about the Mitsubishi being repossessed. That was a lie, right?
Yes.
Every single time you told them that the Mitsubishi was repossessed, every single time you told them that, that was a lie, correct?
Yes.
It was never repossessed in Portage, correct?
No.
Never repossessed in Columbus, correct?
Correct.
And then you told them that you, for a long time in the interview, you denied having any knowledge of the Adams County land, correct?
Correct.
And that was all a lie, right?
Yes.
That was family land, correct?
Yes.
You knew about that land. That was your grandparents' land, correct?
Yes.
And you had gone up to that land with your family. For how many years have you been going up there? Your whole life?
Yes.
You would, so every time you denied knowing anything about that land was a lie, correct?
Yes.
And then you talked about, and just going back to the Mitsubishi briefly, was the Mitsubishi ever even actually up for repossession?
Yes.
But you paid it off using Crystal's account, correct?
Yes.
And in fact, you brought that Mitsubishi up to the Adams County land to clean it, right? You had, and to replace the seat, correct?
No.
So you had the socket set though in the back, right?
Yes.
And that was to replace the passenger seat, correct?
No.
Okay. And you had those wipes in the back, the Armor All wipes. That was not to clean it?
No.
Okay. So was it just to hide it then?
Yes.
Okay. And you would acknowledge that for a long time in the interview with law enforcement, basically you had a lie of omission. You didn't even acknowledge the Mitsubishi, correct?
Yes.
Then you talked about reading about dumping sulfuric acid in holes to get rid of animals online. That was a lie, correct?
Correct.
So now your testimony is that you just dumped all 3.2 gallons in different stages on that burn area?
Yes.
Okay. And that's the truth now.
Yes.
Okay. And then you said in your interview that you had one of Crystal's debit cards. Is that a lie or the truth?
Truth.
So there were 2 debit cards and you had one?
Oh, no.
You did, so there was only one debit card, correct?
Yes.
And you took that from Crystal after she died, correct?
Yes.
And she had never given you permission in the past well, at least in the recent past, to use her debit card.
No.
So you didn't have permission to make any of those purchases?
No.
Not even the tires on June 18th from Walmart for the Ram, correct?
Correct.
So when you were insistent that, oh yes, I did at least have permission for the tires for the Ram, that was a lie too, correct?
Yes.
And again, you maintain through the whole statement that you didn't know where Crystal is. In the first few clips, I think I counted over 11 times not knowing where she is. Many, many times after that, every single time you stated you did not know where Crystal was, that was a lie, correct?
Yes.
And then when you talked about going down to look for Crystal in Watertown, that was a lie, correct?
Yes.
You already knew that she was deceased at that point, correct?
Yes.
Further, thank you.
No further questions. Thank you, Your Honor.
All right, ladies and gentlemen, we'll take a short recess. All right. Return to a seat at council table. Council, are you intending to call any additional witnesses?
No, Your Honor.
So at this point,
I believe all of our exhibits have been admitted. I'm sorry?
422.
Has not been admitted? If I may take a look.
That the officers. Maybe the officers report. All right, 422 hasn't been admitted. That is the officer's report. It was marked for identification and will not be received into evidence.
Understood. Your Honor, I do have a motion to make.
All right.
Brief. With regards to the cross-examination.
Well, let me. Okay. Go
Okay,
ahead.
yeah, whenever you're ready.
Go ahead.
Okay. With regards to the cross-examination of Mr. Rasch, the prosecutor brought up two statements, one by Zachariah Rasch Jr. and Mary Rasch, in essence introduced their hearsay statements and confronted Mr. Rasch with those hearsay statements. This was specifically with regarding to the firearm and access to the firearm. I'm objecting under relevance 403 hearsay, confrontation, state and federal due process. It's inappropriate for a witness to be confronted with a statement that was never introduced into evidence, and we have no possible way of contradicting that statement or impeaching that statement. I move for a mistrial in this case.
I think that number one, do have a way to contradict that statement because they can call those witnesses to say that they, or call the detectives that interviewed those individuals, and the defendant is the one that testified that they observed those individuals see her firing the gun.
He opened the door, counsel. The request for mistrial is denied. Counsel, my recollection, the jury instruction specifically says if facts assume, or if questions assume facts not in evidence, you should disregard the question if in fact the facts have not been proven. That's a serious paraphrase, but it's, the jury instruction already contemplates questions of that nature. Anyway, all right, so your request for mistrial is denied. Where are we going from here?
The defense rests, Your Honor.
Okay.
The state will not be putting on any rebuttal testimony.
All right. At this point, we'll bring the jury back in. The defense will rest. We'll ask if there's going to be any rebuttal testimony. You'll indicate that there isn't going to be any. And at that point, we will dispatch the jury for lunch. It may or may not be a while before they actually get lunch, but during that time we will work on jury instructions, and we'll take our lunch. We'll come back and hear the instructions, do the closings. You folks have already given me rough estimates as to the time, so it appears that would put us, would have the jury, the question sometime around 3 o'clock, 3:30.
Okay. So we're doing jury instructions now?
We'll bring them in.
Okay. Yep.
And conclude the evidence. And again, I'll remind them that they shouldn't discuss the case.
Okay. If we could have a brief 5-minute break after we release the jurors before we discuss jury instructions, Your Honor.
That's fine. All right, your next witness.
Your Honor, the defense rests.
Defense is rested. Rebuttal.
State has no rebuttal.
Evidence is closed. Ladies and gentlemen, here's what's going to happen. The attorneys and myself are going to work on completing the jury instructions. That's the law that the court is going to give to you. We're going to take a break until it'll be about an hour and a half. We're also going to take a lunch as well, somewhere in the middle of that. We'll come back. I'm going to read you the instructions, at least a significant part of the instructions, and then the attorneys will have an opportunity to present their arguments. And in theory, we should have the case to you sometime around 3:30. That may necessitate, obviously, going into the evening hours to complete your deliberations. So, first of all, I'm going to ask: does that the post 3:30 part? Does anybody have any problems with that? All right. So, as I said, I'm going to dispatch you. Understand, though, at this point, you have not been given the complete law that I'm going to read to you. You haven't heard the closing arguments of the attorneys. Obviously, the evidence is all in. But for this time, obviously, I don't want you to just discuss the case. Obviously, I want you to hold firm on that temptation and don't discuss the case. What we will do, and it will be at the conclusion of the instructions and conclusion of the arguments, I'm going to excuse the 4 alternates. I'm going to ask all of you whether you're feeling well, if you're going to be able to continue on. That's I don't let you go until the end. That's the downside of an exchange. You got carrot cake. It's the best I can do. Anyway, all right, you're on lunch. We're going to keep working.
If you don't get to enough, please. Okay.
Counsel, you can go ahead. All right, let's go back on the record. Appearances are the same, sans one defense counsel, who I believe is heading through the door. There he is. All right, I gave to both of you copies of the jury instructions in final form. Attorney Waller,
Nothing on that.
Nothing more, Your Honor.
so the instructions as written are acceptable to both parties. All right, anything before we bring in the jury?
No, Your Honor.
And counsel, for your own benefit, I instruct all the way through. I stop with the closing two instructions. So, and then you'll each make your, what my game plan is, I'm gonna instruct. I expect the prosecution will make a closing argument. We'll take about a 10-minute break at that point, and then we'll come back so that we keep the jury interested and invigorated for the entire balance of the trial.
And we are using the projector, Judge, so.
And because I'm going to, once I'm done with the instructions, I'm going to call on you to give your argument. Let's make sure that that equipment is functioning. Is that what you want up there?
Yes, sir.
All right. So, just remind me when you come to do the podium to do your statement, just remind me to hit the admit to evidence button. All right?
Got it.
All right. Bring in the jury. All righty. The court, you may recall that the court gave you some instructions before you retired for a very, very extended lunch. Did everyone follow those instructions? If you didn't follow them, please raise your hand. Nobody's raised their hand. All right, and just so you folks know exactly what's going to happen, I'm going to read you the closing instructions. And as you probably figured out or will figure out, some of them do mirror instructions that I've given to you before. We know that, okay? So I'm going to read you the instructions. The state is going to present their argument, and then we'll take a 15-minute break. Then we'll come back, we'll hear the argument of the defense and any rebuttal that the state will offer. Then you'll retire to make your decision. All right? That's the roadmap. All right, members of the jury, the court will now instruct you upon the principles of law that you are to follow in considering the evidence and reaching your verdict. It is your duty to follow all of these instructions, regardless of any opinion you may have about what the law is or ought to be. You must base your verdict on the law that I give to you in these instructions, applying the law to the facts in this case, which have been properly proven by the evidence. Consider only evidence received during the trial and the law given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of facts solely as you view the evidence. You, the jury, are the sole judges of the facts. The court is the judge of the law only. The first count charges that the defendant did on Tuesday, June 11, 2024, in the town of Clyman, Dodge County, Wisconsin, did cause the death of Crystal A. Rasch with intent to kill that person and in violation of Wisconsin statute 940.011A, 939.503A, and 973.055 sub 1. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. First-degree intentional homicide, is defined in 940.01 of the Criminal Code of the State of Wisconsin, is committed by one who causes the death of another human being with intent to kill that person or another. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. First, the defendant caused the death of Crystal A. Rasch. Cause means the defendant's act was a substantial factor in producing the death. Second, the defendant acted with the intent to kill Crystal A. Rasch. Intent to kill means the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires the defendant acted with intent to kill, it does not require the intent existed for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even a minute. There need not be any appreciable time between the formation of intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all facts and circumstances, in this case, bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something, while motive may be shown as a circumstance to aid in the establishing of guilt of the defendant. The state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not, by itself, establish guilt. You should give to it the weight you believe that it deserves under all of the circumstance. If you are satisfied beyond a reasonable doubt that the defendant caused the death of Crystal A. Rasch with intent to kill, you should find the defendant guilty of first-degree intentional homicide. If you are not so satisfied, you must find the defendant not guilty. The second count charges that the defendant did between June 12, 2024 and June 25, 2024 in the town of Clyman, Dodge County, Wisconsin, did mutilate a corpse with intent to conceal a crime. This in violation of Section 940.11 sub 2 and 939.503F of the Wisconsin statutes. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. Section 940.11 sub 1 of the Criminal Code of the state of Wisconsin is violated by one who mutilates, disfigures, or dismembers a corpse with intent to conceal or avoid apprehension, prosecution, or conviction for any crime. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. First, that the defendant mutilated a corpse. Second, the defendant mutilated a corpse with intent to conceal any crime. This requires that the defendant acted with the purpose to conceal any crime, avoid apprehension, prosecution, or conviction for any crime. You cannot look into a person's mind to find intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all facts and circumstances in this case bearing upon intent. If you are satisfied beyond a reasonable doubt that both elements of the offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. In reaching your verdict, examine the evidence with caution and care. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find that it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence with any reasonable hypothesis consistent with the defendant's innocence, you must do so and return a verdict of not guilty. The term reasonable doubt means a doubt which is based upon reason and common sense. It is a doubt for which a reason can be given arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or to hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt, you are to search for the truth. An information is nothing more than a written formal accusation against a defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. Evidence is, first, the sworn testimony of the witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits that the court has received, whether or not the exhibit goes to the jury room. Anything that you may have seen or heard outside the courtroom is not evidence. You are to decide this case solely on the evidence offered and received at this trial. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experiences in the affairs of life. Remarks of the attorneys are not evidence. If any remarks suggest certain facts not in evidence, disregard that suggestion. Consider carefully the closing arguments of the attorneys, but their arguments, conclusions, and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given to you by this court. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of the witnesses and the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact that an objection was made. By allowing the testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You jurors are the sole judges of the credibility of the witnesses and the weight to be given to the evidence. The weight to be given to the evidence does not depend on the number of witnesses on each side. You may find the testimony of one witness is entitled to greater weight than that of another witness or even several other witnesses. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. Evidence has been presented relating to the defendant's conduct after the alleged crime was committed. Whether the evidence shows a consciousness of guilt and whether the consciousness of guilt shows actual guilt are matters exclusively for you to decide. Ordinarily, witnesses may testify only about facts. However, witnesses with specialized knowledge in a particular field may give an opinion in that field. In determining the weight that you give to the opinion, you should consider the qualifications and the credibility of the witness, the facts upon which the opinion is based, and the reason given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. It is the duty of the jury to scrutinize and to weigh the testimony of the witnesses and to determine its effect on the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and the weight to be given to their testimony. In determining the credibility of each witness and the weight that you give to the testimony of each witness, consider these factors: whether the witness has an interest or lack of interest in the result of the trial, a witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollection, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice if any is shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. The defendant has testified in this case, and you should not discredit the testimony just because the defendant is charged with a crime. Use the same factors to determine the credibility and the weight the weight of the defendant's testimony, or the weight that you give to the defendant's testimony that you use to evaluate the testimony of other witnesses. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. Evidence has been received that the defendant has been convicted of crimes. This evidence was received solely because it bears upon the credibility of the defendant as a witness. It must not be used for any other purpose, and particularly you should bear in mind that a criminal conviction at some previous time is not proof of guilt of the offense charged now. Now, members of the jury, the duties. Oh. I just wanted to keep going. All right. Very well. Got it.
Well, good afternoon, ladies and gentlemen, and I just want to thank you all for your attention through this week and 2 days of testimony. I know that you had some long days and a lot of detailed testimony, and that all of you paid attention and took notes, and I know all of the parties here appreciate that, because this is a serious case and these are serious facts that we're dealing with, and this is the case about the death, the killing, the homicide of Crystal Rasch. And the jury process itself is an important process, because defendants have the right to a fair trial. They have the right to 12 individuals hearing all the facts and finding them guilty beyond a reasonable doubt. But victims in this state have rights too, and they have the right to a fair process as well in the state of Wisconsin. So I appreciate all the attention that all of you paid to this case. So I recently had a child that finished kindergarten, and while he was in kindergarten, he got in trouble. And the teacher talked to me sort of in private, and then I went and got him, and I said, hey, heard something happen today. I want you to tell me everything about what happened, from the beginning to the end, and everything in between. And I said, don't leave out any details. And I also said, and you need to tell me the truth. Because here's the thing, when you tell me the truth, it's really easy to tell me the same story over and over again, and tell your teacher the same story over and over again. Because the truth is something that actually happened to you. The truth is something that you actually experienced. But when you lie to me, then you have to remember those lies that you told. And so when you lie to me, I can catch you in that lie, because you can't keep the lies straight between me and the teacher. Sometimes you tell me different lies than you tell the teacher. I also told my child, here's a little hint about your mom. Most of the time when I ask you a question, I already know the answer. Law enforcement is basically the same. When they conduct an interview with someone, they are prepared. They walk into that interview with facts, with information, with documents, with photos, with video surveillance, with bank statements. And then they ask the person a question, and they say, we just want the truth. And they let them talk. And you heard from Detective Cotney that during that interview, he said, this evidence is just the tip of the iceberg. Now, ladies and gentlemen, Detective Cotney wasn't lying in that interview. The evidence that they were showing Zachariah Rasch, that was just the tip of the iceberg. And now you got to see the whole iceberg, the top, the bottom, and everything in between. All of the evidence, not just the evidence that they gathered on June 25th, but all the evidence that was gathered throughout the course of this investigation. And then, of course, you got to hear the defendant's entire statement. So on June 26th, the only person who knew everything that happened to Crystal Rasch, the defendant. So just think about that when you go back to deliberations. To really evaluate this case is really a case of deceit and destruction of evidence. And to really evaluate this case, we have to go really back to December of 2023 when Crystal first files for that divorce. She's asserting her independence. She's taking the steps that she needs to stay in contact with her children. She's putting things into place as that divorce proceeds to sell her house, to move into a low-income apartment. She gets attorney David Lang. So he's representing her in her divorce case, in her child custody case, and her personal injury case. Remember, he testifies about that. That last fact is really important because remember, the very last phone call that Crystal made was on June 10th, from her phone in the Adams County area, very close to that property. That was to the attorney, the Gruber law attorney that used to represent her in her civil case, but that represented her and Zach. It's possible that Zach did not know that attorney David Lang took over that civil case. And so he was having her contact the Gruber law attorney. Now remember, attorney Lang testified about her getting her low-income apartment, that she had an optimistic outlook on life, that she was working at maintaining visitation with her children. Even if she was going to lose the case, even if her rights were getting terminated, she was working on maintaining that visitation with her children. She was maintaining contact with her children. She was seeing her children. She was text messaging with Heather Doherty about her children. Heather was keeping her in the loop, and Heather had no intent to cut Crystal out of her children's life. Then you also heard from attorney David Lang that him and Crystal had a good relationship, that she messaged him, and that he never received any correspondence from her firing her until Zach's attorney forwarded an email that was sent in the middle of the night at 1 a.m. on June 12th. And that message was actually from Zach, firing attorney David Lang, but he sent it to the wrong email address. That's the only time that there was ever any indication that attorney David Lang was going to be fired. So then you heard from Heather Doherty. She talked about how Crystal rarely missed her visits with her kids, and how on June 10th, she told her that she wasn't going to make that visit, and she sent her a picture of her son's kindergarten graduation. And this is the type of thing that Crystal would always respond to, but she did not respond to that photo. And she never heard from Crystal after that point. Then you heard from Diana. She told you that the last time that she saw Crystal, sometime around June 6th or June 7th, it was the happiest that Crystal had ever been. She was moving her stuff into storage. She was getting ready to move into the low-income apartment. Her dad was helping her. They had recently reestablished communication over Christmas. You heard from Robin Reels about getting that fake Facebook message, and Robin said that she did not like it when Crystal was spending time with Zach, and I think she testified something to the effect that she didn't like the way that Zach treated Crystal. I don't know what the defense is going to say in closing, but I'm sure they'll make reference to the fact that Crystal kept her relationship with Zach and the fact that she was seeing Zach a secret from her friends. But even the defendant testified on the stand that her family didn't like him, that her friends didn't like him. I think he mentioned one friend that actually liked him of Crystal's, but nobody else liked him. We don't have information of why that was, but just from the evidence presented in this case, we know that he lies to his children about things, he lies to his mom about things, and he lies to law enforcement about things. So maybe it was just that he lied to Crystal about things. So after the divorce is filed, according to Zach's statement, he says everything is fine. The divorce doesn't bother him one bit. Nothing changes. Everything, everything's the same basically. Except for his internet history tells us a different story. And some of the facts within his statement tell us a different story because we know he has to move out of the family home. We know that that is a fact. He has to move back in with his parents. And then we know starting in February of 2024, he starts researching cheating spouse in divorce. So that's on February 2nd. Then February 20th, he looks up another civil case involving him and Crystal. And then he researches and ultimately on February 20th, purchases a firearm and also starts researching silencers. Now, even in his own testimony, he says the last firearm that he owned was back in early 2000. Detectives testified they did not find any other firearm in that home. I'm cognizant we're living in Dodge County. It is certainly not unusual for someone to own a firearm in this county. But rely on your own common sense. Someone who's 42 years old and purchasing a firearm for the first time in about 20 years, what does that say about the person when they're researching that in correlation with the searches related to cheating spouse in divorce and other cases on the Wisconsin Circuit Court access related to their wife? Then he has searches on the 21st of February. How can I disguise my voice? February 24th. How long will fingerprints last on a plastic surface? Then he researches cameras, whether a spouse can install cameras, and whether you are allowed to install hidden cameras. Then he starts researching whether you can find someone's location on Facebook. That's the same day that he's researching about cameras and divorce. Then moving to March 30th, he goes on from researching someone's Facebook location to researching whether or not you can get someone's location through their cell phone. Clearly attempting to track somebody's location. We don't necessarily know who, but the very next day, he looks at the satellite view of 730 Main Street, his former residence and the residence where Crystal Rasch is living. Then on April 4th, he goes into a lot of research on IP addresses. So now he's trying to hide his own identity, trying to figure out how law enforcement can track IP addresses, whether or not they can locate someone else, whether they can locate someone's location using their IP address, if they use a Wi-Fi hotspot, if their phone is off, if it's not accessing the internet, all of these searches. He gives some explanation on the stand. You are the ultimate individuals who are going to judge his credibility. You get to make the determination of whether or not his explanation makes sense. Just the sheer number of IP address searches on that date, the state's opinion is significant. So then we move to April 8th. Things are starting to get more significant now. We have at 12:37 a.m. So remember his work schedule. He works from 2 to 11. So 12:37 is probably after he's getting off of work. I don't know that for certain. I didn't look at April 8th to see whether or not that was a work day or not, but we know that he's sort of that, I believe that would be considered second shift, that 2 to 11 shift. So he stays up in the early morning hours, and now he's searching at 12:37 a.m. The family law case, and then at 3:31, silencer. 334, home built suppressor. 335, how to make a suppressor. 337, how to make a silencer for a 9mm. Again, he gave an explanation. You're the ultimate judges of credibility. You're the ones that get to decide whether or not that explanation makes sense. But use your common sense and life experience. What does it say about a person who's researching their cheating spouse, researching finding someone's location on Facebook, researching trying to track someone's location using their cell phone, researching purchasing a 9mm, purchasing a 9mm, researching the family law case, and then a silencer? Also, we're not talking about a rifle, we're talking about a 9mm. What would you use a silencer for on a 9mm except for some type of nefarious purpose? April 12th. Now we see at 5:10 p.m. he visits the family law case, and then later that evening, can a person feel when they are dying? At this point, the defendant's thoughts are on display via his internet searches. This is what we call planning, premeditation. He's thinking out what he wants to do with his wife. Now we move into May. Remember his own testimony that they were up in Adams County in May. So he searches where to get ammunition in Adams County. Then on May 28th, searching, gunshot wound to the head. This is planning, premeditation. Now we have gone to just thinking about it to really developing a plan. How am I going to shoot her in the head to make it quick and a fast death? Gunshot wound to the chest. Again, this is all well before she gets shot. This is well before June 11th. The defendant gets up on the stand and says that he was thinking about committing suicide because after 5 years of not seeing his kids, he's so distraught about losing them. But remember the testimony from the social worker, Ms. Gordon. The defendant called on June 10th and said he was going to terminate his parental rights. And then on June 17th, 6 days after Crystal dies, he goes into court and terminates his parental rights. He had only seen his children one time since proceedings were initiated. This is not some man who is agonizing over the loss of his children. This is someone who is planning the death of his wife. I think also we have here, will a gunshot wound to the head instant death? Instant death. Again, same time frame, 12 a.m., 12:40, 12:41, 12:45 a.m. Early morning hours, that time where he's stewing, ruminating about his feelings for Crystal, all on full display on his internet searches. Will a 9mm kill an animal if shot to the head? I know the defense might get up here and give an explanation that he was truly searching about shooting an animal. This is a description of what will happen when you shoot someone in the head and how quickly they will die. June 6th. 5 days. 5 days before Crystal dies. How long can you get widow's benefits? Can you get widow's benefits if taxes were never filed? 11:26 p.m. and 11:30 p.m. Again, I know that the defendant said, I was looking for Brenda. There's no evidence that the two of them were even together, that Crystal and Zach were even together on June 6th. And after Brenda's been living there for 2 years now, all of a sudden he's making these searches. There's no evidence that he ever searched this information before on behalf of Brenda. This is about him and Crystal. He's not a widow yet, but he's about to make himself a widow, and he's looking to see if he can benefit financially from that. And turns out, as we know from the evidence, he will benefit financially, at least for a short period of time. So now we also know, we don't know if he's with Crystal, but Diana talks about seeing Crystal around this time. So for all we know, on June 6th, Crystal is actually with Diana, her stepmom, and her father at this time. Now on June 7th, we have Crystal going to the Piggly Wiggly. She's alone at this time. Then on June 8th, that's when we see that video surveillance at 11:40 a.m. that Detective Conkle testified to, where you can see her walking down her driveway and climbing. Likely, this part of Zach's story in his interview is correct, that he does in fact pick her up from the church, probably because Crystal doesn't want Brenda, her mom, to know that Zach is picking her up. And it's likely that Zach does in fact pick her up in the church parking lot sometime around noon. But that video surveillance at 11:40 a.m. from her house is the last time that Crystal is seen alive in Kleiman, Wisconsin. That's June 8th. Now, we then see the vehicle traveling up on Flock to the Adams County area on June 8th. We see lots of Flock hits on June 9th. Nothing on June 10th, but likely still in the Adams County area, Wisconsin Dells area. And then in the evening of June 10th, 11:49 p.m., again, that same time period where he's making all of his other searches, he's Googling child custody attorneys in the Milwaukee area. June 11th, he Googles at 10:41 a.m. How to get to Milwaukee without interstates. And then June 11th at 11:18 a.m., I guess that coyote search. Will a 9mm kill an animal if shot to the head? He says coyote. I say planning, confirming what he should do. So our evidence has them leaving Adams County in the early morning hours, traveling down to the area of Oconomowoc. Then we have our Culver's video where we see Crystal and Zach together purchasing. Here it just looks like drinks, likely also food at Culver's. Zach is wearing that Silverado shirt. And Crystal is wearing that Wisconsin Dells sweatshirt. We believe that's around 10:27 a.m. That purchase is with Zach's card. Then we have the Goodwill footage. This footage here, right here, June 11th, 2024. That is the last time that Crystal Rasch is seen alive. Walking out of Goodwill, thrifting, one of her favorite things to do, with her estranged husband, Zachariah Rasch. We then know that she gets to the back of that vehicle. She changes her shirt. He says standing outside, and that's probably correct. I don't have anything to disagree with that, but there's an indication that she's changing her shirt. We actually find that Goodwill tag and the sweatshirt in the back seat. Now, of note, Remember all of those pictures from Trevor, I believe it's in the lead, how you say his last name. No blood in the back seat. No blood in the driver's side. Only blood in the passenger side seat. So the next search here, again, 1118. Will a 9mm kill an animal if shot to the head? So they get in the car from the Oconomowoc Goodwill. Defendant's story, she wants to go to Milwaukee to look for child custody attorneys. Or does he want her to go to Milwaukee to hire a new attorney to dismiss the divorce? Does he want her to choose him over the children? Does he want the divorce to be canceled so he can get his house back, so he can get access to her money that is in her bank account? The only evidence that we have of anybody searching child custody attorneys is the defendant. We don't have any evidence that Crystal ever did that Crystal ever had any desire to search for child custody attorneys. So then we have the phone go down to the Milwaukee area, goes down to the Greenfield area, and then I know the defendant couldn't remember if he stopped at Speedway before or after, but then can tell you they were in Milwaukee about 10 minutes before 2, and then we have him on video at that there's another stop in the area of New Berlin, and then they head up back towards Clyman. So then we have the defendant's version of events. So he's driving up, it's silent in the car, they're listening to the radio, can't remember which station, and sometime on Highway M, after they get out of Watertown, he doesn't see her reach into the console, even though he's sitting there driving, center console's right next to his left arm. He doesn't know when she reaches in, doesn't know when she gets the gun, doesn't know when she takes the gun out of the holster, but at some point she's got the gun on her lap, doesn't say anything, and then puts it up to her right side, pulls the trigger, and then he just doesn't know what to do. He just keeps driving. He keeps driving there on Highway M, drives back to his house, gets to his house, just stands there, pulls her body out, puts it in the grass, takes the gun, puts it back in the holster, the gun that just put a bullet in her head and killed her, but has no blood on it, her hand that has no blood on it, even though the vehicle is so saturated with blood that when he cleans it with that Hoover vacuum cleaner, that the crime lab can still find the defendant's DNA both on the lip of the vacuum cleaner and in the actual hose, even though there's water and detergent flushing through both of those items. That's how saturated with blood that vehicle is, but no blood on the gun, no blood on her hand, according to the defendant. And then, really, I think the most important response, how did it get the other bullet put back in, right? Detective Casey Young testified it was a loaded handgun, fully, the magazine, the gun was loaded. There was a bullet in the chamber and magazine fully loaded except for the bullet in the chamber, and he unloaded, took the bullet out of the chamber, took the magazine out, made the gun safe. If she shot herself in the head, there should have been one bullet missing. If he did nothing with the gun but put it back on the TV, there should have been a bullet missing. That's the thing. When you're not telling the truth, you mess up facts. Because if it didn't really happen, you can't get the facts straight. So when someone asks you a specific question about the facts, then you can't think of a quick answer because you're not talking about what really happened. I don't know what really happened. I have no idea. I wasn't there. But the evidence tells me that there's blood on the passenger side door. There's blood on the passenger side window. There's dripping blood down the door. There's blood in the vent. Her seatbelt is still on. We know that she liked to be dropped off at the church. We know that he took her down to Milwaukee to attorney's offices. We know that she never tried to fire her attorney. We know she was planning on following through with the divorce. So perhaps, based on the evidence, they got back to his house and he said, "Get out of the car." And she said, "No." And he said, "Get out of the car." And she said, "No. Take me back to the church. Take me back to the church. Take me back to the church." And he stood there from the passenger door and shot her in the head. And then she slumped over and bled out. And then he pulled her out and took her to the burn area. So when he repeated over and over and over again in his interview that she was at the church, that he dropped her off at the church, the reason why he kept saying that is because that's what she kept asking for at the very end. I don't know that for certain, but based on the evidence, that's possible. So now let's talk about his panic. So he burns this body in 4 hours. His body covered with flesh and fats and thick bone that Dr. Jordan Carson, the anthropologist, testified that the bone would have to be crushed. Remember, we didn't find significant thigh bone, arm bone, hands, feet, none of those things. But he burned most of the body in 4 hours, according to his testimony. So while he's in a panic, what does he do? 8:17 p.m., June 11th, his son, Zach Jr. Remember, nobody's calling the police now. Nobody knows that Crystal's missing. Have you heard from Crystal? Nope. Okay. Seems like someone in a panic to me, I guess. Then, to his daughter. So this is UTC, so 7:31 p.m., so about an hour before his son. Have you heard from Crystal? No, I have not. So now his lies that he's going to start, he's roping in his son and his daughter. So then, in his panic, I'm so panicked. What do I do? My wife, the woman that I love, just shot herself. I'm not going to call police. I'm not going to take her to the hospital. I'm not going to call 911. I'm not going to see if she can be saved or if she's still alive. I'm going to burn her body, and then I'm going to send these messages to make it seem like, oh, she's missing. And then I'm going to take her debit card, go up, take her farmers and merchant card, pull money out of that account, and then take her Bank of Lake Mills card and pull $200 out at Quick Trip. Because I'm so panicked, I got to get my first $300 from her bank account. And then, in my panic, in the early morning hours, I'm going to send this message to Janet Brown, from all accounts a person that Mr. Rasch has never met, and through the early morning hours into the early morning hours of June 12th, is going to say, I'm looking for a serious relationship. And you? Now, he says when he testifies, just looking for friendship. But still, even if you're only looking for friendship, when you're in a panic because your wife just killed herself, you're going to go on Facebook and start messaging complete strangers? The other things that he does at this time, he made a payment towards a Capital One credit card. He pays off his Mitsubishi Eclipse, $1,500. He starts researching the Kelley Blue Book value of his Ram because he can't drive that Eclipse anymore. It's covered in blood. And I just wanted to circle back to the gun one more time because I don't want to forget this. Because he says it's not, I understand he says he doesn't clean it because it's not covered in blood. But just think about using your common sense. Is it reasonable that a gun that's used to shoot someone in the head has no blood on it? When it's dropped to the passenger floor and then blood starts pouring out of that person. Just use your common sense. Now going on to June 13th. He starts researching cleaning supplies at Menards, Dirt Devil, portable carpet and upholstery spot cleaner. Do raccoons eat bones? I never actually heard an explanation for that search during direct. And I conveniently forgot to ask about that one. I'm going to tell you, I think we learned from Dr. Carson that unfortunately raccoons chew on bones, but they do not eat bones. I guess we don't know for certain that this was a raccoon, but a carnivore, but they could possibly dig up the bones. Next slide, please. Now on the 14th, we have him at Quick Trip, continuing to pull out more money, $200. And you heard, I believe it was Detective Lake, testify that the max amount that you could pull out of the ATM, $200. So every time he went, he pulled out the max. June 15th, Menards. Here, now, we start with Santeen drain opener, concentrated sulfuric acid. Now he's buying gloves. Now he's buying the cleaner, the spot remover, the OxyClean wipes, the air freshener, and of course, a monster, because he's got to make sure that he keeps his energy up for the task at hand. So you get to decide based on your common sense and the jury instruction based on credibility. Does it make sense that he only burned this body for 4 hours on the 11th, or did he start burning it and realize this is not as easy as I thought, and he went and started pouring sulfuric acid on his wife? His wife, the mother of his children. June 15th now, 5:23 p.m., Harbor Freight, socket set. He never admits this, but likely to remove the seat from his Eclipse. June 16th, we have him, Blaine's Farm and Fleet, black and blue storage tote with, so a 27-gallon storage tote, which we never located. And then the Arm & Hammer laundry detergent. That was the Arm & Hammer laundry detergent. That the crime lab found blood on the handle, but did not come back positive for DNA. And remember the testimony there that the detergent can break down the DNA, but not in the vacuum, not in the Hoover vacuum. That's how saturated with blood it was. June 16th, Ace Hardware, 4 bottles now of 32 ounces of Santeen industrial strength liquid drain opener. Sometimes we're saying Drano, or during the interview Drano, because that's what people can associate it with drain cleaner. This is not Drano. This was extra strength sulfuric acid drain cleaner. June 16th, Walmart Supercenter, more cleaning supplies. June 18th, maximum amount $200 ATM withdrawal. Also on the 18th in Beaver Dam, he's got his oil filter supplies, and then OxyClean, cleaning spray, Armor All wipes, his beach towel, Mario beach towel that he talked about at some point during his interview, and then Walmart Beaver Dam, the tires that he talked about during the interview, that then he admitted on the stand here today that he didn't actually have consent to purchase from Crystal. Then the 19th, the transaction from the DMV in Watertown, registering now that red Chevy Cobalt. And then also on the 19th, he had a transaction at Walmart and then got $100 cash back from Walmart. Going on to his internet activity on the 19th, now searches for a replacement passenger seats at 12:57 p.m. and 12:58 p.m. To replace the front bucket seat of the Mitsubishi. On the 20th, also goes to Farm and Fleet, getting a Monster, more OxyClean, then O'Reilly, the purchase of those LED headlamps, and then on the 20th at 10:30 a.m., the $200 ATM withdrawal. On the 20th, also significant, now he's messaging a woman that I believe that he just starts out with, "Hi, long time, how you fooling," but I think that's from Arlene, so some indication at least that they may have known each other. And then he says, June 20th. Again, this is before Crystal is reported missing. Nobody has reported her missing to law enforcement. Living the single life. Yep, I'm single. She cheated on me while I was at work. Don't know, been single and looking. And then he asked this person out. Seems like looking for a little bit more than friends here. Seems like maybe, I guess this is someone that was in a panic about his wife killing herself or accidentally shooting herself. Now we go to June 22nd. Can you clean a vehicle interior with cold water? Now at 3:56. Do possums eat bones? On the 22nd at 5:55 p.m., we have more purchases of that Santeen drain opener, now from Menards and Johnson Creek. On the 22nd, we also have a purchase according to the bank accounts from Tobacco Plus at the vape place. He does admit to that on the stand here today and talks about that during his interview. On the 22nd, another purchase at Walmart in Watertown where he gets cash back. Now on the 23rd, he goes to Beaver Dam, gets some more Armor All wipes, air fresheners, got to get the Monster, and then goes to Menards and Beaver Dam, gets 6 32-ounce Santeen drain opener bottles. So in total, we track 14 bottles, 3.5 gallons. I guess it could be that he's just pouring it on the fire pit, the surface burn area afterwards, or he's trying to break down that body faster because it's not quite as easy to burn a body as he thought. Using sulfuric acid to destroy, mutilate his wife's body. Now, the 23rd. 6:29 p.m. If you remember the interview, I'm not going to say the quote, but Detective Rolfs does make a quote about what might be going through his head when Deputy Kukan comes rolling up. But we'll just play this portion of the video briefly here. This is the squad camera video that we saw at the very beginning portion of the trial. So this is Wood Road coming up on his residence. He walks up, walks from the burn area. This is the eclipse right here. So walks from the burn area, walks away, closes this, doesn't close these doors, closes this, and then walks up to the deputy. So remember, this was enhanced, and we could tell there's smoke coming from this area. Defendant says, I was just burning garbage. Based on all that I learned about Crystal, I do not think that she was garbage. She seems like a very kind woman that loves her children very much. Based on his behavior and his actions, apparently at this point, that's all he thought of her, is that she was garbage. He was burning her, mutilating her. So now, the 23rd. Okay, so this, 6:29 p.m. 6:29 p.m., June 23rd. 6:42. Is sulfuric acid flammable? What happens when you add gas to sulfuric acid? So now, whatever was soaking in that sulfuric acid, he needs to start burning faster, because now he knows that Crystal has been reported missing. Now he knows that the law enforcement is looking for her, and he doesn't know whether or not that deputy noticed the fire burning or not. So at 7:14, can police get a warrant on Sunday in Wisconsin? How fast can police get a warrant? Then, June 24th, drives that vehicle up to the Adams County property. And remember how little he thought about Crystal. That he took some ridiculous green frog. You're probably thinking, why is the state admitting this green frog into evidence? Because of the sheer ridiculousness that the seat that his wife died in, that when he drives the vehicle up to Adams County to hide the evidence, to hide the where she died, the scene of the crime, he puts some stuffed green animal in the seat and then hides up to his grandparents' property, where they would go to spend time, to relax, to enjoy themselves. Then he comes back down, gets back home to the Wood Road property, and visits what chemistry reaction will happen if I mix petrol and sulfuric acid. We know from testimony that petrol is another word for gasoline. Then on the 25th, he searches Wisconsin missing person alert, missing people in Wisconsin, active missing persons near me. And then we know shortly after that, law enforcement makes contact with him and he is interviewed. And I know you were all listening during the interview, and it was long portions of the interview, and I'm not going to go through all of the parts of the interview. But think about the lies. It was full of lies. He lied about what date he went to the Dells. First he said he went just for one day. Then he said for one night. Then he finally admits 2 nights. But remember, he only admits the timeline of events when he is confronted with the actual evidence. Law enforcement knows the answer to the question before they ask the question. But they let him talk and talk and talk and talk and bury himself in his own lies. Then he lies about what vehicle he drove up there. He said that he's driving that blue Dodge Ram. Why would he lie about that? Because he knows that the Eclipse is the scene of the crime. He lies about this fake Facebook account. She's messaging me from this fake Facebook account. Where is Crystal? I don't know. I don't know. I'm dead honest. I don't know. What did you do to Crystal? I don't know where she is. That's not what we asked. What did you do to Crystal? I don't know where she is. I tried to keep track of how many times he said that phrase. I could not keep track. He lied about going to Menards. He lied about going to Harbor Freight. He lied about going to Ace Hardware. I mean, just think about the ridiculousness of someone who lives in Dodge County lying about going to Menards. He lied about going to Farm and Fleet. He lied about having family land in Adams County. He lied about even owning the Eclipse. He lied about where he was. He lied about when he worked. In the beginning of the interview, they said, all we want is the truth. Detective Cottony said, this is your fork in the road. The defendant took the wrong fork. He took the fork of deceit and destruction of evidence. Do not let him get away with his lies. The final. So this is called the homunculus. And I kind of practice that word a lot. This was created by Dr. Jordan Karsten. So this first one is all the bones that were found. Remember, the yellow were the ones that were not burnt, and the purple were the ones that did have charring, were burnt, and then these dark ones were the ones that were very burnt. So the yellow ones were the ones that had to get rid of when he was interrupted. And what did he do? He probably dispersed some in that heavy green foliage, and then he buried the rest. He buried the rest in that shallow grave that we located in October of 2023. Next slide. All of these bones from the skull, many of them that Dr. Karsten testified were all said, I'm not going to use the fancy term, were broken around the time of his death. So all the injuries from the skull that were the breaks from a result of when he shot her in the head, he was not able to destroy that fast enough. So he had to throw those bones because it was not as easy to mutilate and burn and soak with sulfuric acid Crystal's body as he thought. So again, ladies and gentlemen, at the conclusion, when you retire to that jury room, I'm going to ask you not to believe the deceit, not to believe the lies, and to find the defendant guilty, first-degree intentional homicide, and mutilation of a corpse. Thank you.
All right, ladies and gentlemen, the 15-minute break I promised you is going to be a 10-minute break. There you go. And, but remember, you still need to hear some additional argument from the defense. Out of fairness, please keep your duty to not discuss this case. We'll take 10 minutes. We'll see you back at 2:20. Okay. Yes. Left and with that.
Go to the one on the right side of the table.
My left. Nope. It's not coming through.
Should I try the other?
The equipment is working. I can assure you that. I'm not getting you any place. It's, that's what I use to see if the equipment's working. The equipment's working.
We're gonna try a different laptop, Your Honor.
Did you move to the right port?
I did. It's in the Rasch file.
There we go.
There we are.
You wanna?
All right, let's go back on the record. I put in front of you, or you should have had put in front of you well, now they're going to put in front of you the verdict forms. Do you want to try that? Just let's take a quick look at those just to make sure there's no concerns. All set?
Yes,
No
Your Honor.
problem. Verdict forms?
No objection.
Very good. All right, let's bring in the jury. All right, ladies and gentlemen, is there anybody who did not follow the instructions of the court? 16 minutes, not 15 or 10. There you go. Counsel, please proceed.
Thank you, Judge. Good afternoon. 8 days ago, my partner, Attorney Zahawi, he stood before you during jury selection and told you what his fears were about this case. He told you what his initial reaction was to reading the initial report, the complaint, that Crystal's remains were found on the Rasch property. That his fear was that jurors in this case would hear those facts and that they would immediately jump to the conclusion that Zachariah must have murdered her. Several of you in particular said that although that would also have been your initial reaction, that you would still want to hear more and see more of the evidence in this case before you could reach a conclusion. The reason that you all are sitting on this jury panel is because we expect that each of you has not prejudged Mr. Rasch and will fairly and deliberately consider the evidence that was presented in this trial. You took an oath as a juror at the beginning of this case to try the issues submitted to you, and unless discharged by this court, to give a verdict according to the law and the evidence given in this case. The law and the evidence. Let's talk about the law first. Mr. Rasch has been charged with 2 offenses. First-degree intentional homicide is count 1. That requires that the state prove beyond a reasonable doubt 2 elements of that offense. 1, that Zachariah Rasch caused the death of Crystal Rasch, and 2nd, that Zachariah Rasch acted with the intent to kill Crystal Rasch. This entire case, in terms of the homicide charge, boils down to intent to kill. And did the state prove beyond a reasonable doubt that Zachariah intended to cause Crystal's death on June 11th, 2024? It is the most serious crime that exists under Wisconsin law. The second charge is mutilating a corpse. That offense also has 2 elements that the state has to prove beyond a reasonable doubt as to each element. One is that Zachariah Rasch mutilated a corpse. And second is that Zachariah Rasch mutilated a corpse with the intent to conceal any crime. That requires that Zachariah Rasch acted with the purpose to conceal any crime, avoid apprehension, prosecution, or conviction of any crime, not just avoiding prosecution for a homicide, but any crime. These are the two crimes that you have to determine whether the state proved their case beyond a reasonable doubt. What you know from the very first day of trial is that Zachariah Rasch is presumed innocent. He started this trial with a presumption of innocence, and it carries forward through even to today, even to this minute. Only if you, as the jurors in this case, go back to deliberate and reach a unanimous verdict of guilty on either count does that presumption of innocence disappear. The burden of proof in this case is high, as it should be. In criminal cases, the state is required to prove each and every element of every offense with proof beyond a reasonable doubt. That burden of proof is higher in criminal cases than in any other type of case. If this were a civil matter, the burden of proof would be preponderance of the evidence. If this were even a TPR trial, it would be clear and convincing evidence. But in this criminal trial, it is proof beyond a reasonable doubt. In jury selection, Attorney Zahawi asked questions of the panel about how people make decisions. What kind of information somebody might need if they wanted to purchase shoes or an appliance or a house. You can think of each of those as representing different standards of proof, different amounts of information that you need to make a decision. The bigger the purchase, the more proof you would need to make that decision. The decision that you make today, in this case, will be the biggest decision that any of you will ever make in terms of the impact that it will have on the life of a stranger. Proof beyond a reasonable doubt is the highest burden of proof in the law because criminal cases bring the highest stakes. The potential loss of someone's liberty. Let's talk about the evidence that was presented in this case. I think we can all agree that the vast majority of the evidence that was presented in this case related to things and acts that occurred after June 11th. During the opening statements, Attorney Zahawi asked you to keep three questions in mind as you listened to the evidence in this case. First, what element of what offense does the evidence tend to prove or disprove? Second, can the prosecution rule out that this was an accident or a suicide? And third, are you left with any lingering questions, any unsolved questions after the case was presented to you in full? The state's strategy in this case appears to be to overwhelm you with evidence regarding what happened after June 11th. We've seen the great efforts that they have made to introduce the same evidence many times and in many ways. For example, the bank records were introduced. Then they presented images and videos from the various locations where purchases were made. Then they presented to you the flock camera photos showing Mr. Rasch's vehicle traveling to these destinations. Then they presented you with cell tower tracking maps. All of this is just compounding evidence that shows the same point. The bank records on their own and a handful of pictures would have been sufficient, but we all sat through hour after hour of this kind of presentation. The same applies to the remains that were recovered, pictures of the excavation site, dozens upon dozens of photographs, and then testimony from the various experts to then re-show a lot of those same images over and over again. For example, with Dr. Karsten, bone fragment by bone fragment, each and every individual fragment was shown to you. The same goes for the Google searches. Pictures of the searches and then accompanied by images of screenshots taken from the Cellbrite report, and on and on. Day after day, the prosecution has labored on in a tedious and repetitive manner. But despite their efforts to flood you with this information, they did very little to investigate the days, weeks, and months that led up to June 11th. There was almost no evidence presented about what happened inside of that Mitsubishi on the drive back from Milwaukee on June 11th. That's the critical question that needs to be answered by you in this case. And instead of conducting an investigation that examined the days and the weeks leading up to June 11th, this investigation that was conducted presumed that a murder had occurred and really only sought to find evidence to support that initial conclusion. Whether you call it jumping to a conclusion, confirmation bias, or tunnel vision, law enforcement in this case assumed from the very beginning that Zachariah was responsible for Crystal's death, and they did not investigate that there could have been an alternative reason for her passing. In the words of Detective Contney, verbatim, he sat on that witness stand and he told you, "I think we can all put two and two together." He reached that conclusion from day one of being assigned to this case and the course of the investigation that followed that assumption. He did precisely what we are asking you as jurors in this case not to do. Over the course of this trial, you heard from 21 different witnesses, 20 from the state, and finally from Mr. Rasch himself this morning. But how many of them had relevant evidence, relevant testimony to provide regarding the intent element of count one, the first-degree intentional homicide? I want to briefly review the evidence that was presented to you over the course of the past week. Captain Bake, he assisted with the initial search warrant that was conducted at the Wood Road residence in the early morning hours of June 25th. He also participated in further searches of the property in October, and he put together a timeline of law enforcement activity in the case that was submitted as an exhibit. But he did not provide any testimony regarding the intent element of count one. This was the law enforcement activities Rasch investigation timeline that he put together for you. Next, we had Diana Free. This was Crystal's stepmother. She provided a lot of information, background information regarding Crystal and the family. She testified that Crystal had a learning disability, that she had never held a full-time job, and prior to receiving disability income, she had been supported by her parents. She last saw her on June 6th, and when she returned from a trip on June 23rd, Diana Free was the person who called the police to report her missing. In her words, she thought Zachariah would be the last person Crystal would be spending time with. She was unaware that Crystal was trying to find a new lawyer, and she was unaware that she had signed up for that carrying a concealed weapon permit class. She also did not provide any testimony regarding the intent element of count one. Heather Doherty was next. She was the foster parent for the Rasch children who has now adopted them. She testified that Crystal was lower functioning and needed extra guidance in many aspects of her life. She talked about Crystal's supervised visits and that Crystal had canceled her visit on June 10th because she had been told that Crystal had strep throat and did not want to come and potentially get the kids sick. She mentioned that Crystal skipped one of her children's kindergarten graduation ceremony, and she was also unaware that Crystal was hanging out with Zachariah. She also did not provide any testimony regarding the intent element of count 1. Robin Reels was next, Crystal's friend for 24 years, who said that they spoke nearly every day, either by texts or by phone calls. Crystal told her on May 24th that she was going to the Dells with friends, but it didn't say that it was with Zachariah. Robin testified that she believed that Crystal had stopped seeing him well over a year ago. She also did not provide any testimony regarding count 1. We next had Kitty Gordon, who was a senior social worker with Dodge County Human Services. She was assigned to the cases involving the Rasch children and the TPR matter that was pending. She provided services to Crystal. She made it clear to Crystal that the Dohertys were excellent foster parents and that she was recommending her rights be terminated and that the Dohertys go through with the adoption of those 4 children. She told Crystal that she would be able to maintain a relationship with those children of some sort. She testified that Crystal refused to engage in mental health therapy, that she was unable to finish the parenting classes that were ordered because they were too hard for her. She largely had supervised visits, and that she was also unaware that Crystal was hanging out with Zachariah. And she also did not provide any testimony regarding count 1. None. Next, we had Deputy Kukan. He was the first law enforcement officer that was involved in this case. He spoke with Diana, with Zachariah, and with Robin. He also did not provide any testimony regarding the intent element of count 1. Next, we had Lieutenant Taylor Niels. He's the head of the Detective Bureau with the Dodge County Sheriff's Office. He primarily testified about the bank records of the transactions using Crystal's debit card after June 11th. He also testified to the videos that were collected from the Culvers and the Goodwill in Oconomowoc. He finally testified about some of the search warrant photos from the Wood Road search that occurred at the end of June. But he also did not provide any testimony regarding intent. He did provide through his testimony the videos from the Culvers and the Goodwill. And I'd like to play those for you now. Forward it to about 35 seconds. You can see in the video that Mr. Rasch is paying for the transaction with his own money, with his card. He then takes the number for their food order. The next video I'd like you to watch is that video that you've seen a portion of previously from the Oconomowoc Goodwill. And we'll just watch the first couple of minutes of this video. You see the Rashes leaving and approaching the silver Mitsubishi right at this moment. This is the portion of the video where he's acting as a shield, so she's changing her top in the parking lot, blocking other people's view of her topless, essentially, in the parking lot. You'll be able to see that when that rear door closes, that Mr. Rasch then goes to the front passenger door and opens the door for his wife. And that's occurring now. He then travels behind the vehicle and then enters the driver's seat. The next witness that we had was Attorney David Lang. As District Attorney Will mentioned in her remarks, this was Crystal's lawyer for all three of her cases, for the TPR, for the divorce case, and also for that car accident case, the personal injury. He testified that she was no longer going to be able to afford the home that she lived in for a decade, and that she would be downsizing into a one-bedroom subsidized apartment. It was his testimony that she never missed a visit with her children, and that she was looking forward to moving on in her life post-divorce. But he was unaware that while she was communicating with him, she was also looking to replace him. He provided no testimony regarding the intent element of count one. Next, we have Detective Sergeant Bradley Conkle. He primarily testified about the flock images in this case, but he did not provide any testimony regarding count one. This flock image is the image that was shown to you all during the trial that showed what everybody suspects to be Crystal Rasch sitting in the front passenger seat of Mr. Rasch's vehicle on Friday, May 31st. So this occurred about 12 days before her death on June 11th. They were also able to obtain additional flock images from Saturday, June 8th, as they traveled up to the property in Adams County to spend the next 3 nights at that location, Saturday, Sunday, and Monday. On Tuesday, June 11th, these are the images that they obtained of the Rasch vehicle in very close proximity to those 2 law firms that were the subject of those searches on his cell phone. And we see the times, June 11th at 1:42. The next witness that we had was Detective Casey Young, who primarily testified to the evidence that was collected from a search of Zachariah's phone, as well as other search warrant photos. The Taurus handgun that was recovered from the dresser in his bedroom was in plain sight. This is what the bedroom looked like at that bedroom on Wood Road. That was Zachariah's bedroom. And this was a picture of the handgun laying plain as day out in the open on the dresser by the TV. Detective Young also provided testimony about the Google web search history that you've heard so much about. The next witness was Detective Kelsey Becker. He drafted the preservation request for Facebook and the search warrants for 4 accounts and testified about the gun, the CCW class, and the holster, but did not provide any testimony regarding the intent element of count 1. I feel like you can sense a theme that's occurring here. Detective Rolfs, next witness, testified primarily about the scene and the excavation photos at Wood Road, the search of Crystal's bedroom, her medications. He did not provide any testimony regarding count 1. This was the pill organizer for her medications that we've talked about at some length, which show that the pills for Thursday, Friday, and Saturday in the AM are gone, which makes sense with the time that she left her residence on Main Street in the village of Kleinman. We know that she left on Saturday morning, but none of the other pills were taken for her multi-day trip up to Adams County. Judge, if you could lower the lights so they can read this one, please. This was the calendar, the wall calendar that was in her bedroom that there was testimony about also. If you need to have a closer look at this, obviously some of these exhibits will be going back to the jury room, but you can see on June 11th, the day that they traveled to Milwaukee, she had an appointment scheduled for an MRI on that particular date that she also did not attend. Next, we had Detective Michael Lake. He testified regarding the surveillance videos and photos of all the various transactions made with Crystal's card, the history of the gun purchase, and the pictures of the recovered Mitsubishi. He also did not provide any testimony regarding intent, regarding the homicide. This is essentially the form from the government that tracks gun sales. And you could see in the middle of the form that this gun was purchased on February 20th, 2024 from Fleet Farm. And this is the purchase receipt, although the receipt at the top has a July date, but that was because that was when the receipt was reprinted. The gun itself, though, was purchased on February 20th. He testified at great length about all of the transaction surveillance, videos, photos, all the information that you had heard about previously through the bank records and the other means. The next witness was senior forensic scientist Trevor Nallad from the Wisconsin State Crime Lab. He testified largely about the processing of the 3 vehicles that were owned by Zachariah. We had the 2002 Dodge Ram truck, we had the 2005 red Chevy Cobalt, and then obviously we had the 2023 silver Mitsubishi. the primary vehicle of interest. From his testimony, it was very clear that whatever happened with Crystal happened in that front passenger seat of the silver Mitsubishi. And based on the blood staining that occurred, the seat belt, he testified, was engaged, being used at the time that whatever incident occurred to her. Based on the blood staining that was visible, that was his testimony. The seatbelt was on, and it was on her body when the gun went off. But obviously, he could not testify as to what caused or who caused that gun to be fired. So he also had no testimony regarding the intent element of count one. Next, we had forensic dentist, Dr. Legro, who identified the tooth from the burn area as being Crystal's, but obviously was not able to indicate how or why she passed away. Next was from Bodie Technology, DNA analyst Benetta George. This was the woman who testified via Zoom. She testified that the bone sample that was provided to her through the process that they utilized at their laboratory returned back a positive DNA test result as being a bone from Crystal Rasch. She also obviously could not provide any testimony regarding how she passed away. Next, we had senior DNA analyst from the Wisconsin State Crime Lab, Kimberly Wroblewski. She testified regarding what items were submitted to the crime lab and which items she subsequently tested and what those results were. She provided testimony that the trigger guard, and the handle of the gun were not tested, and she said in her own words that it was due to the case circumstances. We now know that the case circumstances were something that was relayed to her by Detective Contney. Instead of thoroughly testing the gun, they chose instead to test all of these random items for the presence of Crystal's blood. We all know that the blood on those items would have been Crystal's just based upon the other very obvious evidence in the case. She obviously didn't have any testimony to provide regarding the intent element of count one. And instead of testing the gun in multiple locations, they decided to test the Hoover, the vacuum, in 3 different spots. They decided to test the handle of a bottle of detergent. They decided to test a vape pen. They decided to test all of these items that held so little evidentiary value instead of testing the instrument that caused the death of the person in this case. Next, we have from MOCIC, the acronym, the Middle States Crime Information Center, the analytical supervisor, Matthew Anderson. I believe he went by Tyler, but Matthew was his first name. He testified about the data mapping of cellular phone data records that he was provided with from the Dodge County Sheriff's Office. All of the provided testimony that he gave was only from June 11th to June 25th. He testified that he had data from earlier dates, but he was only told to analyze data for presenting at trial here, data from June 11th forward. He admitted that it would have only taken seconds for the software program that they utilize to ingest the data for those earlier dates, and it wouldn't have been a difficult thing for that information to have been presented to you as the jurors here. He obviously doesn't have information about what happened to Crystal. I want to play just one video for you. This was the video from June 11th that showed all of their travel that day from the 2 phones that were connecting, both Crystal's and Zachariah's phone. phone is moving down from Adams County now, south and now east to Oconomowoc, where it stays there for about an hour at the Goodwill and the Culvers. And now it's moving back down to Greenfield, near where those two law offices were. Stays in that vicinity for about half an hour. And now the vehicle is making its way back up to the residence on Wood Road. And we know from this video that we saw previously, the vehicle returned at approximately 3:30 p.m. and did not move again until about 10:30 that same evening, when Zachariah went and withdrew money later that evening up in Juneau. Instead of playing videos of Mr. Rasch traveling to Menards and other stores, wouldn't you have been more interested in seeing what the traffic patterns were for Crystal and Zachariah in the week or the weeks leading up to June 11th before her death? Instead, they played all of these videos from essentially June 25th backwards to June 11th that really had no consequential significance to this case, and they played them in reverse order for some reason. Next, we had forensic anthropologist Dr. Jordan Karsten. He testified about the identification of all the various bones that were found on the Rasch property through the various searches that were done there. I believe there were at least 3 separate searches that were done. He was a very informative person. It was very educational. He gave us, quite an anatomy lesson, but he really was not able to provide any information, once again, regarding the intent element of this homicide charge. The last witness for the state was Detective Justin Contney, the case officer for this matter. Testified, to quite a few different items, cleaning up various topics or unanswered questions, but primarily he testified about the very long 11-hour interrogation that he and Detective Rolfs had with Zachariah. Even after the 11 hours, we saw all the lies. We saw all of the, non-responsive answers to many of the questions. But throughout that process, Zachariah never said, "I killed Crystal Rasch." We know that much. And then the final witness, obviously, is Zachariah himself. He testified this morning, so it should be very fresh to you. And his testimony regarding what happened inside of the Mitsubishi is the only evidence that you've heard on that matter. He chose to testify this morning. He didn't have to. And he also provided answers as to why he made some of those Google searches. He talked at length about the days preceding Crystal's death and what they were doing. And he specifically talked about how this death occurred on June 11th. Admittedly, after her passing, he engaged in a series of terrible decisions. The disposal of her body, burning it, using her debit card, subsequently lying to the police. But what he did after the fact of her passing is not evidence of how she passed away. There was a comment that was made by DA Will in her remarks that, he lied constantly and consistently to the detectives during that interrogation. If he had told them what he told you this morning, do you think that the result in their minds would have been any different? No. They still would have arrested him for her homicide. Whether he told them the story, the truth of what occurred that he told you today, or whether he continued to deny knowing where she was, the result was going to be the same in their minds. Remember, Detective Contney said we all know what 2 + 2 equals. The decisions at that point in time, not only did they have the information, because as the DA Will said, don't go into these interrogations not knowing what answers they want. They know precisely what answers they want. And he was not going to provide the answer that they wanted, and therefore he was going to be deemed a liar. He testified that he was going to be scared, that he was scared that he was going to be blamed for her death. And given who he is and the history, this was a legitimate concern. So those were all the witnesses that you heard from. So what are we left with now? Let's start with what we know about Crystal. We know that she was leading a double life of sorts. While she complained to others about Zachariah, she was secretly continuing their relationship. Everyone who testified in this trial that knew her, that was a civilian witness, nobody knew that she was still seeing Zachariah. And these were all supposedly the people who knew her best. Her stepmom, her best friend, her caseworker, the foster mother of her children, and her lawyer, who says that she would contact him multiple times a week. She was secretive when she was meeting with Zachariah. She hung out, we know, with him for days at a time. We know from testimony that she had some cognitive issues. She was described as being low functioning and needing assistance. We know that she was receiving disability income. There was really an attempt by those civilian witnesses to portray her as somebody who was very optimistic and looking forward to the future. I think there is a natural tendency that when somebody passes away, that we want to look back on their life and see things in a light that's oftentimes better than things might actually have been. I think it's easier that way to think that there were no signs that she was struggling, because then there's nothing that they could have done in hindsight to prevent her death. But we know that she was facing some significant and serious, difficult life circumstances. She was about to lose her home of a decade and downsize into that subsidized one-bedroom apartment. She was going to be losing her parental rights in the very imminent future to all 4 of her children. Even the caseworker that she was so close with was going to recommend her rights be terminated and that these kids be adopted by the Dohertys. And third, she was going to be getting divorced. Any one of those things individually would have been a lot to deal with, even for a person who was of ordinary functioning, who was in a good mental space. These are incredible, difficult life events. And many people have engaged in self-harm when faced with even one of those 3 monumental events that Crystal was facing. We know that she wasn't seeing her mental health providers and that she likely left her medication behind when she went up to Adams County that weekend. We know she missed her child's kindergarten graduation. Odds are likely that the strep throat excuse was just that, an excuse. We know that she lied to her mom on June 10th when she said that she did in fact visit her kids. Detective Contney's report said in fact she did not. We know that she skipped her MRI appointment, the following day when she went to Milwaukee. We know that she was in Milwaukee trying to find new lawyers as perhaps a desperate Hail Mary. Maybe a new lawyer can help save this case and maybe my rights to my children won't be terminated. But when she went to Milwaukee, she was turned away because in their lack of planning, they didn't make an appointment. And maybe as ordinary people, we realize that you can't just walk into an attorney's office just off the street and expect to have, a consultation on the spot. Is it reasonable that somebody in her condition, facing her challenges, and in a desperate moment, might try to harm herself? It is. It is reasonable. It would not be surprising at all when you take a step back and you look at the realities of her life. She was a person who in ordinary times required substantial assistance to deal with ordinary affairs of life. And these were not ordinary times for Crystal. Now let's talk about Zachariah. You've had an opportunity to observe him this past week. Out of most people in the courtroom, you're the closest to him. You've seen his demeanor. You've seen his lack of communication, quite honestly. I don't think I've ever had a client as quiet as him during the course of a trial. You listened to his testimony this morning, and you saw hours of his interrogation video. I don't think anybody would describe him, and this is not an insult to him, but I don't think anybody would describe him as a particularly sophisticated or cunning person. He has an 11th grade education, and he has spent his adult life largely working simple factory assembly jobs. As you have observed him this week, you may think of him as being somewhat of an odd person, strange even perhaps. But what I think is largely true about Zachariah is that he has spent the majority of his life living on the edge of society in ways that are both literal and also figurative. You saw pictures of the house that he resided in. We can all agree that these are not normal circumstances. That house is secluded and it's isolated. He's a man of very few words and few friends. We know through the testimony of a variety of witnesses that many people in her family, Crystal's family, and her friends disliked him, even prior to June 2024. That much was clear. It's understandable why a person like Zachariah, when placed in the position that he was, with her dead in his vehicle, would believe that nobody would believe him if he told them that she did this to herself. Does it excuse any of the actions that he engaged in after she died? No, it doesn't. It doesn't excuse the fact that he disposed of her remains in the way that he did, or that he utilized her debit card, or that he lied to law enforcement. But if you were Zachariah, it's understandable to know why he acted and he did the things that he did in the days and the weeks after she passed away. You heard a lot about all of the things that he did after her death, but none of his attempts to dispose of her remains is proof of intent that he actually killed her. You heard Mr. Rasch testify this morning, Zachariah. He admitted to the numerous lies that he told law enforcement, and he also admitted to disposing of Crystal's remains. You can choose to believe what he said today in whole, in part, or not at all. It's your job to judge the credibility of any witness. But there is objective evidence in the record as to what happened on June 11th. That's the reason why I wanted you to see those videos one last time in my closing. So let's consider the last verifiable actions that were taken by Zachariah. They woke up very early in the morning in Adams County. They traveled to Oconomowoc. You saw the video at Culver's. They're standing in very close proximity to one another, standing as couples often do when they're ordering food at a counter. You saw him take out his wallet and pay for the drinks and the meals for him and his wife. You saw then the next video of him at the Goodwill when they were exiting the store. He shielded her from public view as she was changing her clothing in the parking lot from the sweatshirt to the shirt that she bought there at the Goodwill. After that, He then goes to the front passenger door and opens the door for his wife to sit in the vehicle. I can't remember the last time I opened the passenger door of the car for my own wife. But you saw him do it. And maybe it's a good reminder that maybe we should do that more often. Then what we know unequivocally from the flock pictures that I showed you, and keep in mind, we start this day in Adams County, a couple hours away from Greenfield, Milwaukee suburb, Wisconsin. That he then drove her to Milwaukee from Oconomowoc, which took another hour or so, in an attempt to find new lawyers to fight her case that at that point she was still interested in fighting. And we know that she was met there with disappointment, that she couldn't meet with a lawyer at that moment in time. And we know that he returned back to his residence on Wood Road by 3:30 that afternoon. Those flock images of when they're in Greenfield are approximately 1:42 to 1:45. The state wants you to believe that despite what you saw earlier in that day, chivalrous behavior by Mr. Rasch towards his wife, that somehow something shifted so dramatically in that hour and 45-minute drive back from Greenfield that this individual who's on video buying meals, shielding her, opening doors for her, and driving her a considerable distance in an effort to, help her with her case, somehow then turned into a murderer. Something just flipped a switch, and instead of the gentle, kind person that you see on those videos at the beginning of June 11th, that by early afternoon, he has then decided that he's going to kill her. They presented no evidence as to why he would do such a thing. There was no evidence presented in this case about progressive, increasing hostility in the days and the weeks leading up to June 11th. Nothing. One of the questions that Attorney Zahawi asked you in opening, and I referred to it at the beginning of this, was, would you have lingering questions unanswered when all the evidence was submitted in this case? DA Will, on several occasions in her closing argument, said this was a premeditated, purposeful homicide. If that was the case, why buy a gun from a licensed dealer? If his intent when getting the gun was that he was going to use it to murder his wife, why would you buy it from a licensed firearms dealer? Why would you sign up for a carrying concealed weapon permit? Another entry into a government database saying that you had a handgun now. If the gun was in fact the murder weapon, why was it left in his room in plain sight when we know that the following day after Deputy Kukan came to the house that he took the Mitsubishi up to Adams County? Why wouldn't he stash it in the 80 acres of woods or in one of the numerous trailers on that property? I didn't know whether the state's theory was, was this premeditated or was this an impulsive act? DA Will has told you several times this was premeditated. This was premeditated, no doubt in her mind about it. If it was a premeditated act, why would he do it in the car? Why would you do it in a place that would be so difficult to clean? And if you were going to do it in a car, why would you do it in your new car? He had a 22-year-old truck and a 19-year-old Ford Cobalt, but we're supposed to, expect or understand that he would do this in his 1-year-old car that he's still making payments on? It doesn't make any sense. Other questions. If this was premeditated, they were at the rural Adams County wooded property for days. Why wouldn't he do it there? Why would he go to Milwaukee? Why would he take her there? Why would he help her try to find a new lawyer? Why would he buy her a meal? Why would he do any of these things? And in terms of the investigation in this case, why didn't law enforcement investigate her mental health? Why didn't she take her medication with her? What would happen if she suddenly stopped taking her medication? Why didn't they interview more of her family and friends? Why didn't they interview more civilian witnesses who knew her personally and may have had insight as to what was happening in her life in the days and the weeks leading up to this incident? And why not test the trigger and the trigger guard and the handle of this firearm? It is arguably the single greatest piece of evidence that they had, and they neglected to do it. Why not investigate what was happening before June 11th? Why didn't you see what her travel patterns were, how often she was hanging out with Zachariah? You haven't been presented with any of that information. And ultimately, what reason did he have to do it? Manner of death. Natural causes. We obviously can eliminate natural causes, right? It's pretty obvious. Let me just backtrack one sentence. The third and final question that was posed to you during the opening statements was, would the state be able to prove beyond a reasonable doubt that this was not an accident or a suicide? So then we have these 5 manners of death. Natural causes, undetermined, accident, suicide. If the state is asking you to find Zachariah guilty with proof beyond a reasonable doubt of homicide, you have to eliminate with proof beyond a reasonable doubt that this was not an accident, proof with beyond a reasonable doubt that this was not a suicide also. You have to rule out those options first before you can decide whether or not this was an intentional act. This is part of the instruction for burden of proof and presumption of innocence. It's the reasonable hypothesis. If you can reconcile the evidence upon any reasonable hypothesis consistent with Zachariah's innocence, you must do so and return a verdict of not guilty. You must do it. The law requires it. A reasonable hypothesis in this case, based upon the evidence and the lack of evidence that was provided to you all, is that Crystal Rasch shot herself. Coupled with the shocking lack of evidence regarding intent, we respectfully ask you to render a verdict of not guilty on the homicide charge. Thank you for your time.
Very well.
Is that one still got juice, or should I try?
Oh, let me grab all those out of your way. Oh, you need the mic. Sorry.
I don't need it. He went through a lot of witnesses and talked about a lot of the witnesses. He got to Detective Casey Young. He didn't talk about him very much and whether or not his testimony proved intent. He didn't talk about those internet searches much. I spent a lot of time on my closing talking about how those internet searches showed us how Mr. Rasch's mind was working. is jury instructions. First-degree intentional homicide. While the law requires that the defendant acted with intent to kill, it does not require the intent existed for any particular length of time before the act is committed. It need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even a minute. There need not be any appreciable time between the formation of intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if at all, from the defendant's acts, words, statements, if any, and from all the facts and circumstances in this case bearing upon intent. That one, defendant's acts, words, and statements. We have a lot of acts, we have a lot of words, and we have a lot of statements. When you retire back to the jury room, look at all of those things, both before, premeditation, and after. Consciousness of guilt. That is one of the jury instructions that you will read about concealment, and that can be consciousness of guilt. When you conceal a crime, that you as jurors can decide is consciousness of guilt. When you immediately text your son and daughter, "Where's Crystal?" Consciousness of guilt. Those things can be used as circumstantial evidence by you to determine intent. Detective Casey Young, I think it testified for an entire morning. That entire testimony was intent. And you ask, why did he leave the gun out? Because he cleaned it. He purchased a cleaning kit. When he bought the gun, he cleaned the gun. Even his version of events don't make sense because there was no blood on the gun. He cleaned the gun. That was his new toy. He was so proud of that gun. He was so proud of that CCW class. He immediately messaged his daughter about it. That's why he kept it, and he thought he could get away with it. He wasn't going to destroy it because he thought he cleaned all the evidence off of it. Remember, how long do fingerprints last on plastic? He cleaned that gun. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all the circumstances. I don't have to prove motive, but I think we have motive. Divorce, money. Crystal had over $8,000 in her account. He drained it. He drained it down in a matter of 2 weeks. You are not to search for doubt. You are to search for the truth. You are the judges of credibility. What does that mean? Let's go to that jury instruction. You will get these, but really, some of the highlights of credibility. Believability. The clearness or lack of clearness of the witness's recollections. The reasonableness of the witness's testimony. Bias or prejudice, if any has been shown. Possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend to either support or discredit the testimony. Like, for example, lots of other previous lies that have been told to law enforcement throughout the entire course of the investigation. There were a bunch of questions up on that screen that the defense said were left unanswered. Remember, closing argument is not evidence. But those questions, number one, you saw the binders and boxes and stacks of evidence. You saw them talking to the social worker about the defendant's the victim's mental health counseling and her medications. We looked into her mental health and her medication. There is absolutely no evidence in this case that her failure to take those medications would result in her committing suicide. No evidence, no testimony, nothing. And then the question is, why did he shoot her in the car? I don't think he wanted to shoot her in the car. She would not get out of that car. She wanted to go back to that church. That is why she was shot in the car. He was going to shoot her at the residence, so he had time to get rid of the body, but he did not want to shoot her in the car, and she would not get out. The defense keeps telling you over and over again, she wanted to switch attorneys, she wanted to switch attorneys, she wanted to switch attorneys. The only evidence in this case that she wanted to switch attorneys is the defendant's own testimony. You give that testimony the weight of evidence that you believe it deserves, given all of the information you've learned throughout the course of this trial. They talked about, the state, they presented all this extra stuff that they didn't need to present. There's nothing about intent that the state presented. First of all, this is a homicide trial. It is important that you as jurors understand the entire investigation that law enforcement did. There was over 400 exhibits in this case. You needed to understand the investigation from start to finish. Because remember, during this defendant's statement, I don't know where Crystal is. I don't know what happened to her. So at the point where we get the Mitsubishi, we have to prove that's the crime scene. So that's why we tested it, all the blood in the Mitsubishi. That's our crime scene. We have to prove that he had her in that vehicle. They were in that vehicle together. That's why we tested that vape, to prove that the two of them were together. And then we tested the portions of the gun that we thought were most likely to have blood. The initial test, no blood, no DNA, so we tested the holster. These are all things that law enforcement went through to prove this case. We did not have some sort of laser focus on the defendant. People said Crystal was missing. We saw that video with Kukan where he's walking from the smoke, closing down that vehicle, and then that vehicle heads to Adams County. Then he's buying sulfuric acid. In the business, we call that clues. Okay? We know that sulfuric acid can damage a body. And so the immediate thing that law enforcement thought was, he's trying to get rid of her body. We got to get there to try to find what evidence might be left in this case. Then we searched for 3 days and didn't find any bones. And then finally found bones and had to build a case from there. All the while, the defendant was maintaining, I don't know where she is. 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 10 hours. Never said she shot herself. They say, we'd still be in the same spot. We don't know because he never said that. He never once said that until the mountain, the iceberg of evidence came down upon him. Then he gets on the stand. She pulled a gun out and put it to her head and shot herself, but the gun didn't have any blood on it. Remember also her mom's statement about how Crystal felt about firearms. When they tried to take her shooting, she put her hand over her ears. Is it reasonable that that same person that had that attitude then just pulls a firearm out of the center console and just, without a word, puts it to her head and shoots herself? Again, I'm not going to go through all this testimony, but they say, we go through all these steps. We prove where his vehicle is. We prove where his phone is. We prove that he's the one that's using his phone. We prove the transactions happen, but we have to prove that he is actually the one committing all of those transactions. We proved that the two of them were together. The data for the weeks prior all existed. Defense had that data. Now they want to stand up here and say, we didn't see those maps. We don't know what was happening. They had it. They had all of that information. It wasn't some mystery, but now they want to get up in closing and they smoke and mirrors because there's a mountain of evidence against the defendant and say, well, the state didn't do this, the state didn't do that, the state didn't do this. Do not search for doubt. You're supposed to search for the truth. Look at all of the evidence. You decide the truth. Then they say, I can't remember the word they used, but the defendant's not very cunning or sophisticated or something like that. Well, he's sophisticated enough to almost immediately upon Deputy Kukan leaving, Google's search warrant, Fourth Amendment, finds the statute, looks at the statute. That is pretty sophisticated. I mean, he's not a lawyer. That is pretty sophisticated. I mean, look at all of those searches, but that one in particular shows how calculated and cunning he is. Ladies and gentlemen, don't believe the deceit. Destruction of evidence, consciousness of guilt. Detective Young's testimony, 3 hours, 4 hours, proof of intent. Please retire to the jury room and return verdicts of guilty on both counts. Thank you.
Counsel Roach. All right, ladies and gentlemen, I used to hold this up to my head because that would be like those of you who are old would remember Johnny Carson and Karnak, but I don't do that anymore. All right. Anyway, this is the 4 jurors who are going to be excused. I will ask: is there anybody who doesn't feel well enough to go forward and see this matter through to deliberations? Nobody's raised their hand. All right. All right. The jurors who will be excused are juror number 4, juror number 7, juror number 22, and juror number 45. Now, members of the jury, the duties of the court have been performed. The case has been argued by counsel. The court has instructed you regarding the rules of law that should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and, as upright citizens, to render a just and true verdict. The following four verdict forms will be submitted to you concerning the charges against the defendant, Zachariah Rasch. One, reading, we, the jury, find the defendant, Zachariah Rasch, guilty of first-degree intentional homicide as charged in count 1 of the information. Another, reading, we, the jury, find the defendant, Zachariah Rasch, not guilty of first-degree intentional homicide. Another, reading, we, the jury, find the defendant, Zachariah Rasch, guilty of mutilating a corpse as charged in count 2 of the information. Another, reading, we, the jury, find the defendant, Zachariah Rasch, not guilty of mutilating a corpse. It is for you to determine whether the defendant is guilty or not guilty of each of the offenses charged. You must make a finding as to each of the counts in the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count must not affect your verdict on any other count. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may legally be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. That person's vote is entitled to no greater weight than the vote of any other juror. When you have agreed upon your verdicts, have them signed and dated by the person that you have selected to preside. If I could have the bailiffs approach, please. If you could swear the bailiffs.
Do you swear that you will, to the utmost of your ability, keep all jurors sworn on this trial together in some private and convenient place, subject to the direction of the court until they have agreed on their verdict or are discharged by the court, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon? So help you God?
Ladies and gentlemen of the jury, it is now time for you to deliberate. You can discuss the case. That needs to come off. All right, we did have one sidebar during that session. During that sidebar, I simply asked the council approach and simply asked if there was any concerns about any of the jurors. You obviously had the opportunity to watch them during the course, and sometimes concerns are brought to the attention of the court, and rather than excuse somebody and then have somebody say to me, well, geez, I for one reason or another, I thought that juror should have been eliminated. I asked you to approach. Both indicated they did not have any problems with any of the jurors, and the 4 alternates were released.
That's correct, Your Honor. Just out of curiosity, how were the 4 alternates selected? Was it random?
Random. It, like everything else in our life, the computer randomly generates four alternates. You can see the sheet if you like.
No, that's fine. I just
I
didn't know if you had a 16-sided die up there or something.
And if you want me to explain how a computer handles things, you are completely in the wrong place.
Understood.
So, all right, folks, I would ask that you remain in close proximity to the court. If you do leave, please make sure the bailiffs have your phone numbers. All right, we stand adjourned.
Should we grab that charger headset that the one jerk walked out with? Should I put it up here or should I just leave it there? It's not gonna need to be charged. It shouldn't have to be charged. I'll just grab a new battery for it. That battery that is there, she said she had that one, said it was dead. This one? Yeah. Oh no, should I grab that front one? No, that's a different channel. So just grab the old, yeah. You know what, I'll just leave it in there. Okay, when she comes back in. I'll leave it there for 5 minutes and I'll put it back. Okay.
headset so they can hear.
Yeah, they'll need them, yeah. As a matter of fact, that your one juror, did you move it back down to her seat?
No, he plugged it back in.
Oh, she's gonna need it at the end there.
Should be 10 minutes.
pictures of can we see pictures of the inside of the Mitsubishi Eclipse? And we have gone through all of the pictures or attempted to give them all of the pictures of the interior of the vehicle. Also, the second question, which is, can we see the pictures of the ammunition? And that is 102, 103, 101, 102, and 103. Answer that question. 287, 288, 289, 290, 291, 292, 293, along with 300, 301, 302, 303, 304, 305, 306, 307, 308, 309, 317, 318, 321, 322, 323, 324, 325, 326, 327, 328, 329, 330, 331, 332, 333, 335, 336, 337, 338, 339, 340, 341, 342, 343, 344, 345, 346, 347, 348, 349. Those are the exhibits that I intend to send back. Any objection?
No, Your Honor.
None from the state.
All right, and the record would reflect that all of those exhibits were just displayed for council so they could take a look at what I have referenced, the exhibit numbers that I have referenced. They will be sent back. We are adjourned.
Thank you.
I would not travel too far, I would suspect.
We'll be in that room.
Thank you.
Oh, no.
It was convenient because in Graham County, it's not like, it's like a courthouse on a square. And, right across the street, there was like a place where you could
Oh,
buy shoes.
store.
So I only had to wear my New Balance kicks for like the mornings.
Remember the time?
But the
No,
people-
Sean's got a better story.
So with the, at the back of exhibit, so that's the skull, so it would be in 400, the first, yes. Yep. So there's a PowerPoint that would just have that page. Yeah, but that's the last page. That's fine. Yeah, so it's the last page of 401.
So, that's what, just grab that. All right, let's go back on the record. Appearances are the same. We do have another question. The question is, can we have the diagram of the skeleton sent back? That was part of Exhibit 401. I've taken that page off, which was the last page. We will mark it for identification as 401A, and we'll send that back.
Thank you, Your Honor.
Thank you.
There's 401A. Give you the exhibits back. Fantastic.
Just waiting for Mr. Wooler. Guess he went to the restroom.
All right, we are back on the record. Appearances are the same. I've been advised that there is a verdict. We will have the jury come in. I'm used to there being more of you. Ladies and gentlemen of the jury, do you have a verdict? If you could hand that to the bailiff, please. All right, the court has received 4 verdict forms back, 2 of which are signed, 2 of which are unsigned. The first of the signed verdicts reads, we, the jury, find the defendant, Zachariah Rasch, guilty of first-degree intentional homicide as charged in count 1 of the information. It is dated this 9th day of June 2026, and it is signed by Juror 34 as foreperson for the jury. The second reading, we, the jury, find the defendant, Zachariah Rasch, guilty of mutilating a corpse as charged in count 2 of the information. It is again dated this 9th day of June 2026, and it is signed by jury 4-person, juror number 34. Ladies and gentlemen, it is necessary for me to ask each of you if what I have just read into the record represents your verdict. And we will start. Juror number 9, is this your verdict?
Yes.
Juror number 11, is this your verdict?
Yes.
Juror number 12, is this your verdict?
Yes.
Juror number 13, are these your verdicts?
Yes.
Juror number 16, are these your verdicts?
Yes.
Juror number 24, are these your verdicts?
Yes.
Juror number 26, are these your verdicts?
Yes.
Juror number 33, are these your verdicts?
Yes.
Juror number 34, are these your verdicts?
Yes.
Juror number 36, are these your verdicts?
Yes.
Juror number 38, are these your verdicts?
Yes.
Juror number 42, are these your verdicts?
Yes.
Any objection to the polling?
None from the state, thank you.
None from the defense.
Ladies and gentlemen, with this, your service is ended. You are free. You are free at this point to talk with whomever you want about your service here as a juror. If somebody contacts you, and I'm going to tell you this, I tell every jury this, and this is well over 280 juries that I've had as a judge. I tell every jury the same thing, and I've never had a call. But if in fact you are contacted by someone you don't wish to speak with, and they persist, you should contact the court immediately. As I said, I've never had that situation, but I have told everyone that. Folks, on behalf of the parties, on behalf of the court, thank you very much for your service. We put you through some very, very hard days, and we recognize that. A lot of the listening was after lunch, and sometimes presented some challenges, and we completely understand that. But what I do want to tell you, is that as a judge, and you heard me say this before, as a judge, I'm extremely lucky to have served here. I'm lucky because of people like you who take the responsibility of showing up, the responsibility of giving your time to resolve disputes. It is absolutely amazing, and as I said, as I wander out of here in a few short days, I've been very lucky. So thank you very much on behalf of all the parties, on behalf of the people of Dodge County, the state of Wisconsin. With that, your service is ended. Folks, if you do have any questions that you want to ask me, I will be available after these proceedings. We'll have a few housekeeping things to attend to. Will not be long, and I will be available if there's any questions that you want to ask. Very well.
The state would ask for judgment on the verdicts and to revoke bail.
Court will enter judgment on the verdicts. The court will, at this time, revoke bail. As to disposition, what I would ask is that both of you contact tomorrow my judicial assistant to schedule a date. You just heard me tell the jury I am done as of July 31st of this year, and I would like to get this resolved and brought to a conclusion by that time. With that, we are adjourned.
Thank you.